afraid, like we're too close to the beginning.
Yeah. Nice. Good morning. Thank you for being here. I'm Ashley Ede. This is the LBA litigation section, CLE on effective voir dire and jury selection. We're going to have Judge Olu Stevens speaking first from the judge's perspective on effective voir dire, things that he's seen from the bench. Obviously, he's in a great position to know what works and what doesn't. Judge Stevens has served as circuit court judge in Jefferson County since July of 2009. He began his legal practice in 1996, and during that time served 2 years as the assistant Jefferson County attorney. Judge Stevens is a member of the Louisville Bar Association, the Kentucky Circuit Judges Association, and the American Bar Association. He earned his undergraduate degree in psychology from Morehouse College in Atlanta and his JD degree from George Washington University Law School. And obviously, we want to encourage you guys to, ask questions. Obviously, this is a small gathering, so, encourage you to participate as much as possible. Thank you, Judge Stevens.
All right, Ashley, good morning. Thank you very much. See Scott Burton is joining us, our Executive Director. Good morning to you. Thanks for having me back. It's nice to be back. Though we're going to have a few more folks, but I'm sure we'll get some folks in here eventually. If not, then I understand we're recording this thing, so maybe some folks will watch it. It's a pleasure to be back. It really is to the LBA. I haven't been here in a little while, and I served as president of the Louisville Bar Association almost 10 years ago, and I'm a student of history. I define history to include precedent, but not just precedent, how precedent works together, hand in hand. What does the story tell? And when I was president-elect of the Bar Association, I went about the business of reviewing the minutes of the Bar Association to see where was the history of the LBA. And I discovered that in 1955, the LBA, which had previously stood for exclusion, began to stand for inclusion. They admitted 3 black lawyers, the first 3 black lawyers, to its membership in 1955. And I also noticed that as I walked the halls of the Bar Association, there were no pictures of black lawyers, because the pictures that you see that adorn the walls are pictures that predate the admission of the 3 lawyers. And so, to my knowledge at least, the first picture of an African American that adorned these walls was my picture as the president of the Louisville Bar Association. And so I thought, well, our pictures should stand for inclusion. I was talking about this 10 years ago. And 10 years ago, if you look at the bar briefs, you'll see that President Stevens wrote an article, a bar briefs president's page on the issue of inclusion in the history of Louisville law. And what I call it is the history of Louisville law, not the black history of Louisville, the history, the entire history. And I talked about, at that point in time, inclusion and how important that is, and how important it is for people to feel as though they're included. And I thought it was important for our walls to send a message. And so I gifted the LBA a piece that was designed at the ENS Gallery by my friend Walter Shannon, my friends Walter and Kathy Shannon. And they designed a piece with the pictures of the 3 lawyers who were admitted to the bar as a sign of inclusion and not exclusion in 1955. And that's what hangs here today at my directive, because I've given it as a gift, and it's a conditional gift, that it remain displayed prominently for all to see. And it's beautiful. Harry McAlpin, Charles Anderson, Ralph Richards. Said 55. Well, guys, I've got to read my history is 53, right? Is the mic on? It's not on? Well, perhaps they didn't hear me say it. It says on. Still not?
Not there yet.
Okay. It's 53. It's not 55. I've got 10 years will erode your memory. So 1953, November 1953 is when these lawyers were admitted to the Louisville Bar Association. We talked about then the importance of inclusion, not exclusion. And so today I've been invited here graciously to speak on the issue of jury selection. And I'm going to do that. The materials that you have there are very important. And if you would please review those. And if you call me, if you have any questions about what's contained in there, because there's some other subjects that I'd like to get to. I'd like to talk today about justice and jury selection. Justice and jury selection. What does justice mean? What does it mean? It means fairness, right? Justice equals fairness. And that's all that's required when we're talking about the law, and in particular when we're talking about jury selection. There's been a lot of talk about discrimination in jury selection, talk about the Batson case, talk about the case that's currently before the Supreme Court of the United States that deals with the issue of Batson, and the importance of making sure that individuals are able to serve as jurors without being discriminated against on the basis of race and what? Gender, right? That's very important, and that's why that case is before the Supreme Court, because the movements are seeking to protect who? The defendant? No, the juror's right to serve without being discriminated against. And that case is all about notes and what have you, and an interpretation of Batson, and what are the parameters of Batson? Does Batson have any teeth? Because we're all concerned, most of us at least, that Batson should have some teeth, that we should prevent discrimination against jurors on the basis of race. But before we reach the issue of Batson, before we get to Batson, there have to be jurors to protect. If there are no jurors to protect on the basis of race, then Batson is a nullity. So the question becomes, and we are faced with it right here in Louisville, Kentucky, in jury selection, and that's what I've been asked to talk about today. So I'm going to talk about it. What should our jury panels look like if we want to protect against discrimination on the basis of race? How should they be composed? Should they be all white? Or should they be diverse? Because if they're all white, we can get an all-white panel, and then we don't have to worry about Batson. We don't have to worry about its implications. it's a nullity. Why are we so concerned about protecting black people from discrimination in jury selection when we're not concerned with protecting their right to participate in the first place? Right here in Louisville, Kentucky, in 2015, we have an individual, a prosecutor, who's lost a criminal jury trial. A black defendant was acquitted by a jury of 8 whites and 4 blacks. Why are you mentioning that, Judge Stevens? What is the significance of that? Why is that important? Why is that noteworthy? Well, I'll tell you why. Because after that acquittal, the prosecutor went to the Supreme Court of Kentucky and claimed that he was deprived of his right to an all-white jury panel. And you should take note, because this is a momentous occasion indeed. In fact, this is a first in the history of American jurisprudence, that a prosecutor would lose a case and go complaining about the racial composition of the jury. What does that say about what he is doing? Why is he doing that? I'll tell you why. It wants a different result. What does that say about our community, that we would permit something like that? That we would condone this? What does it say when we are silent? Individuals who come before me on a regular basis. The case in question that I have mentioned, the trial judge set aside that first jury panel composed of 40 whites and 1 black. The motion was made by the public defender to set it aside for the reasons that he outlined. And the judge denied. And he made it again. And the judge denied. And he made it again. And he made it well. And the judge granted the renewed motion. Third time, the judge granted the motion. And so the judge is called into question. And the nation is talking about the judge dismissing jury panels. But where's the public defender who asked for it to be done? Where is he? He's silent. Where are the criminal defense lawyers who walk into court after jury selection has begun and request that this judge dismiss an entire jury panel for lack of diversity? Where are they with their impassioned arguments that they make before Judge Stevens in Jefferson Circuit Court? They're nowhere to be found. Why are they not speaking up? You have to ask them. But Judge Stevens is speaking up, because Judge Stevens understands that this is not about Judge Stevens. I've lost a lot of cases. I've been reversed on a lot of things. And I'll be reversed on more. It's just the way it is. Same thing for all of my colleagues. But I care about this. Why? Why do I care? Because I care about justice and fairness. And I want to know, who else cares about justice and fairness? Who else cares about equality and inclusion? Who's going to be quiet while this is done in our community? And who's going to step up and say this is not right? This is not how we want our community to be represented. We don't want to go down in history as being the folks that went to the United States Supreme Court to argue our right to an all-white jury in 2015. We don't want to go down in history that way. Just because somebody else does, just because the Jefferson Commonwealth's attorney does he want to go down in history? He will live in infamy. And he will be the butt of every prosecutor's jokes. You lose a trial and then you go to the Supreme Court of the Commonwealth of Kentucky to complain about what? The composition of the jury? How dare you? How dare you people should be standing up saying we are not going to take this. This is not an issue of law. This is an issue of right. And yet and still, we're engaged in discussions about the discretion of the trial court and whether or not the judge should have gotten a cross-section of the community, whether there was systematic discrimination. Was that proven? We know it's 40-1. In Jefferson County, we get our pools, and we have 13 circuit judges. And amongst those circuit judges, we got to divide that up. So I'm going to call down to get my 41, and I got my 41. 40-1, randomly selected, 40-1, 40 white jurors, and 1 black juror. And I got a motion to set it aside completely. And get what? Another random selection. Who's that going to hurt? Oh, no. We're entitled to those jurors that you randomly selected to begin with. They have a constitutional right to hear this case. Show it to me. Show it to me that 41 random people in this community have a constitutional right that trumps the defendant's right to a fair trial. Show me that 41 randomly selected individuals have a constitutional right that trumps the juror's right to serve without being discriminated against. Show me where 41 randomly selected people have a constitutionally protected right that trumps the trial judge's obligation to entertain a motion to dismiss the jury panel for lack of diversity. Tell me that those 41 individuals who don't know the defendant from anybody have some right that is superior because they've been inconvenienced for a day. I handle criminal felony trials. We're talking about, by definition, things that happen to people where they will be incarcerated if convicted for a year or more. Don't tell me about your day that you wasted. I don't want to hear about your day that you wasted. Because there's certain things that are much more important than your day that you wasted, or that the courtesy of having to sit down and you're randomly selected 41, and I've shown you, I've performed a disservice to you. I've not been courteous to you. Please. These people don't have any constitutionally protected right. And why is it, by the way, that the Supreme Court has accepted certification of law? Let's talk about that. Raise your hand in here if you've ever had the Supreme Court accept certification of law for something that you've done. Petition the Supreme Court of the Commonwealth of Kentucky for certification of law, and it was granted. Or have you done it at all? Anybody? Oh, here it is. It's rare. I had a colleague of mine that's been around for 20 years, and he wanted to know how this happened. So I didn't get what I should have gotten, but that's another issue. Certification of law, I find, says this. The law is not on, there's no law on point. There's no law on point. That's what they're arguing. There's no precedent. Judge Stevens has done something that no one has ever done, and we don't know how to handle it, no law on point, and we want you to tell Judge Stevens that he's wrong. And you know what? We're going to accept that. We're going to take that on. So when I hear and I read that someone is going around town saying that they have law on their side, that I've done something that's illegal, then I wonder, how do you reconcile that with your representations to the Supreme Court of the Commonwealth of Kentucky, that there is no law on point, and that the trial courts need direction? How do you reconcile those concepts? The discretion of the trial court when it comes to setting aside jury panels. Let me correct myself. here's the issue. What is the discretion of the trial court to grant a motion to dismiss a jury panel for lack of diversity? That's the question. And we do know this. Motions to dismiss jury panels have been made in this Commonwealth many times before. There's nothing revolutionary about a lawyer making a motion to dismiss a jury panel. Nothing. There's nothing noteworthy about it, because I will tell you that it happens on a regular basis. I have presided, for trial lawyers. I've presided over 131 felony criminal cases and complex civil cases in 6 years. I have presided over more than 147 jury selection processes, cases in which, that includes the 131, but some of them settle before we swear the jury. What is the discretion? Well, out of 147 jury selection processes, I have had occasion to set aside 2. Pardon the pun. I think someone is judicially exercising his discretion. Perhaps too much so, if you know anything about numbers. My wife's here, she's the smartest person I know. She's always talking about numbers and logic and things that people don't want to hear. And we talk about 147 and that means 145 are right here where they need to be, and they've never been set aside. 145, but there are 2 that are what? That are outliers. They're outliers. You draw them randomly and you get something that's crazy, that's way, way off. It's not even close to representative. It's, for example, 40 to 1. The question is, what is to be done with those outliers? And some would have you believe that it involves systematic discrimination you need to prove more, you need to prove more. I'm going to get to that. You're going to remind me. I'm going to get to it. Systematic. I'm going to talk about it. You need to prove more. 40 to 1? Well, no, it's systematic. There's some other people in other divisions of Jefferson Circuit Court, they got distribution. Tell it to the defendant. Tell it to the defendant. Tell it to the folks that have been denied on this particular panel, that have been excluded on this particular panel. Tell them and see how that makes them feel any better. Your trial's going on right now, and it's 40 to 1. But guess what? The good news is Joe Blow's trial's next door, and he's got 10 black jurors. You okay? You good? Come on. Come on. We have to deal with what is in front of us. And let's take a short trip to our history. We're talking about history. Because we're talking about history, and history includes precedent. But it's not just precedent. It's how it works together. You have to read it all together. Anybody can recite precedent and rely upon precedent, but if you rely upon history, you've got a strong position. Before Batson, there was a case called Swain versus Alabama. And it was the law of the land from 1965 to 1986. It dealt with discrimination in jury selection, race discrimination particularly, hadn't reached gender yet. And it said, essentially, it's not good enough for you to prove discrimination in the case. Yeah, you might get the prosecutor wants all black people off the jury. So what? You need to prove more. You need to give me more. You need to prove systematic discrimination over the course of time by that prosecutor. Then if you show that, you got it. That's all you need to do. Is just go back in the history of all the cases and make sure that you're able to prove it. And then we'll deal with what he did in this case. Well, Batson originated here in Jefferson Circuit Court. And I won't go into the details, but the bottom line is that it involved discrimination against jurors, and that case went to the Supreme Court of the Commonwealth of Kentucky. And the Supreme Court of the Commonwealth of Kentucky decided that Swain was the law of the land, that this was just discrimination within the case at best. You haven't proved systematic discrimination. But somebody thought better. They thought there was a better way to do this, a fairer way to do this, that involved protecting the constitutional rights of the defendant and the right of the particular juror to serve in a particular case. And so they went to the Supreme Court of the United States of America, and they made their argument that systematic discrimination does not sufficiently protect the juror. And a new standard was born. They threw out systematic. They got rid of systematic. And they came with Batson. And what does Batson say? It lays out what we are to do in what? The particular case. We're no longer dealing with systematic discrimination. Fast forward to 2015 in Louisville, Kentucky, just like Batson, the case in the Jefferson Circuit Court. And the argument that is going to the Supreme Court of the Commonwealth of Kentucky is this: systematic discrimination. They need to prove systematic discrimination. When are we going to learn? History, not precedent, history. It combines, it works together. You got to know where we've been. And we need not repeat it. We don't need that stain in our community. Do you want to be known as the people from Kentucky who challenged this in 2015, who said, oh, we're going to go up because we want to protect our all-white jury? No systematic discrimination. Let's learn from history. Let's protect the rights of the defendant in a particular case. Let's speak for the jurors who are excluded in the particular case. Let's use some common sense when we talk about 40 to 1. Because guess what? The trial judge dismissed that jury, got up another jury, and that jury was, I think, 37-3-1 or 37-4, something like that. Still majority white, 37-4. Went with it. 4 ended up on the jury. 4 African-American jurors on the jury. 8 whites on the jury. They acquitted the defendant. Fast forward. That was last year, because these folks were doing stuff I didn't even know about. But then I got another case a couple weeks ago, and had a new lawyer who was defending the case for the public defender's office. And I suggested to him, and I'll tell you that, hey, look, this panel is a little weird. It's 37-3. We want to do something. We go out on the record and we stated, if you have any motions, you need to make them. I'll give you an hour. He came back. I want to make the motion, Judge. It's granted. We're going to set this aside. We can get another random selection up here. 37-3-1. It's a little funny. I think I like your reasons. I grant it. We set them completely aside. Don't listen to anyone telling you otherwise. Completely. They're gone. 41. We got a new 41. 31 white jurors and 10 black jurors for a total of 41. 5 and 9. Total seated 14 jurors. 5 black jurors, 9 white jurors. 2 were eliminated by random draw at the end. They were both white. That gave us a jury of 5 blacks and 7 whites who deliberated on the case and convicted the black defendant of cultivating marijuana. Yeah, it is the most serious and harmful and threatening offense of our community. In our community is that, and it got so, and it was so heinous that it attracted the attention of WDRB. They're going to do a story on this cultivating marijuana. We heard you set aside the same week one of my colleagues entered a directed verdict in a murder trial. She acquitted the defendant, and good for her. She did what she needed to do. I don't criticize it, but I'm saying she acquitted the defendant in a murder trial herself, took it away from the jury. But they don't care about that. They care about Stevens and what he's doing, because he is trying a cultivating a marijuana case, and he's setting aside jury panels. Come on. Come on. Let's, what I am urging, all within the sound of my voice, and anybody who may be watching this, is to stand up. Stand up and say, this is not what we want. Let's leave alone for a second. Let's move from the realm of law and into the realm of logic and into the realm of what the lawyers say all the time. I hear them say, bring your common sense. Don't forget your common sense. I don't know that I'd ever say that. I'm a bard anyway. Let's move into the realm of common sense. Even if you believe that Judge Stevens was wrong in sustaining a motion to set aside a jury panel, that does not deal with the action of the Jefferson Commonwealth's attorney, who in this community, composed of 21% black people, in this community that has a jail population that is 55% black, that does not deal with his actions in going to the highest court in this Commonwealth and seeking relief on the basis of the fact that this judge deprived me of my all-white jury. Don't do that. Somebody should talk to him and say, let's not even reach the law yet. Don't do that. You don't want to be remembered this way. You don't want to be the person who lost a jury trial and announce it for everybody and then say, oh, by the way, he didn't give me my white jury. Because if he'd have given me my white jury, then I would have convicted him. That's what that's saying. Yes, it makes you scream, doesn't it? It's squeamish. You can't do this. You should not do this. If your ego is bruised, let it heal. But don't let it heal at the expense of people in this community. Don't let it heal at the expense of unity in this community. Don't divide us based upon some lie that Judge Stevens found 12 white people to be can be impartial, couldn't be fair. Don't lie to the people. Don't do this. If you have an interest in those particular jurors, if you think those particular jurors are your jurors for your case, then do what you need to do in the case. This issue has been addressed any number of times, but it's always addressed in this context. The defendant makes the motion to set aside the jury panel. The judge denies it. The case goes on. The defendant is convicted. And as issue number one for appeal is, I asked that judge to set aside that jury for lack of diversity. Oh, no, he didn't abuse his discretion. Deny. Affirm. That's how these cases come up. All right? And what is the defendant seeking? What are they seeking? Justice in what? In the particular case, they're seeking relief. They want to be eventually acquitted. They want to walk. That's why they're doing it. This case could have also arisen by way of what is called a writ of prohibition. I told you that I give time, and I can't recall the particulars of the case in question. On 2 weeks ago, I gave an hour. You don't like what I'm doing? There's a higher court than me. And you can file a writ of prohibition in that case, saying we want this particular jury in this case. But when you wait and you see a jury that is 8 whites and 4 blacks and they acquit the defendant, that case is gone forever. That case no longer exists. And when you seek relief, you are not seeking relief in the case anymore. You're seeking broad relief. You're seeking relief that applies across the board, no matter the circumstance. and regardless of the circumstance, and without regard to the circumstance, recklessly seeking relief, no matter the consequence. And in this case, the consequence is dire. It involves excluding individuals from jury panels in our society based upon race and taking away a judge's discretion to grant a motion to set it aside. That's what we're talking about. Because somebody doesn't like what Judge Stevens did on one case. Lick your wounds and go on home. Lick your wounds and go on home and live to fight another day. But don't send this to the highest court in this Commonwealth seeking some relief on that basis. It is embarrassing to all of us. It speaks badly of all of us who believe in what? Justice and fairness, equality and inclusion. So again, when I leave here today, I'm going to have a meeting, a telephone conference with the president of the National Bar Association. We're going to conference, Mr. Benjamin Crump and I, on the telephone. And I'm going to tell him these things. And perhaps I'll send him a video. I'll buy it from the LBA. Another donation, Mr. Ferguson. I will send Mr. Crump a video of what I've said here today to see if anything resonates with him. Because we should not stand by, we should not sit quietly while our community suffers this. We should not remain quiet while someone is doing this to our community. We should stand up and we should say, it's not right. We don't want all white juries in our community. Live by what you have told the people you were going to do. And that is represent the people, not just the people, all the people. And when you go to the Supreme Court of the Commonwealth of Kentucky and you ask them to ensure your right to select all white juries, you're not acting on behalf of all the people. You're not acting as a representative of all the people. His own standards, national standards, require what? Prosecutors to see what? Juries that are representative of the community. 40 and 1. 40 and 1. How is that representative? So we're going to be talking about that and their involvement here on behalf of people, all people. And my hope is that they will take action. But there are individuals in our community who have stepped up and answered the call. They will take action. It's just Judge Stevens talking. Judge Stevens is not a party to the case. Although if he had filed a writ of prohibition, Judge Stevens would have been a party to the case then. And he knows, guess what? Judge Stevens would have filed a response, and they would have been talking about it. But we have individuals in our community who have stepped up, and they're going to answer the call because they understand what the implications are when we talk about jury selection. They understand how important it is to our system of what? Justice, fairness, equality, inclusion. And I'm urging you, if you hear my voice, I'm urging you to step up and do something, say something, be heard. Don't let this go by and then complain later about how they're talking about us or who's being excluded. Don't sit back silently saying, I'd rather not get involved. Believe me, Judge Stevens would not rather not get involved. But I get involved because I have to. Not because I want to. And I'm challenging folks that are recording this here. There's people in this very building who purport to represent the lawyers are sitting silently while this is happening. safe and it's comfortable. I understand. But sometimes getting justice is uncomfortable. Seeking fairness and equality is uncomfortable. Here's how I'm going to end. The Reverend Dr. Martin Luther King Jr. is cited extensively by individuals on both sides of the fight. And they use his quotes for their purposes. I guess I use it for mine. Because I understand what this is about. And there are individuals who need to speak up. And they're not. They're silent. And Dr. King famously said, there comes a time when silence is betrayal. Do you all have any questions? Is there any question that I can answer for you about this talk about jury selection, Mr. Meinhardt?
Good morning, Judge.
You've come in and we're talking about the particulars of jury selection. I took a slight departure from the last time that we were together. And I was just asking everybody if they had any questions.
What's the citation?
Commonwealth versus James Doss. Commonwealth versus James Doss.
I have a couple questions.
Please.
And I'm so glad you departed from
Thank
the
you.
original outline.
Thank you.
It's great. I don't practice a criminal law. All my cases are civil, and I've only been over for trial once, and some jury selection that way. How do you see this applying in civil cases? And I guess more broadly, for those of us who aren't over doing these criminal cases, what can we do to support?
Great question. Thank you so much. Here's what I will say. That number one, this has broad applicability to criminal and civil cases, because what we are talking about is representation, and what we're talking about is inclusion, and the representative sample of the community should be the same whether it's a civil case or a criminal case. Now, the practical realities of it is that it arises more in the criminal context because the defendant is incentivized to raise it depending on the race of the defendant. There have been many cases that I've had, all white juries and white defendant, and it never came up. Should it have? Probably should have. But does it? No. And when I say it probably should have, it is, just to be clear, it arises by way of motion by one or both of the parties. It does not arise in any way by any judge, including Judge Olu Stevens, just deciding that I don't like the jury, man, I'm gonna throw it out. Judge Stevens is dismissing juries. No, Judge Stevens is considering motions to dismiss juries based upon lack of diversity or any other factor. And I'm granting those on a very, very rare basis, but I will if it's proven. So the answer to the first question is it has applicability to civil cases as well. The answer to the second question is that if you believe anything about what I have said, aside from the issues that relate to the particulars of how to select a criminal jury, if we go back into the realm of our everyday common sense and our desire to protect our community from the stain of discrimination and prejudice, then we had to speak out. We had to let the Jefferson Commonwealth's attorney know this is not what we want for our community. We had to let him know that respectfully. And I've told people that. He's the one that's pushing this. Everybody's talking about the Attorney General. Believe me, he's going to get some communication too, but there's a transition going on. He's getting it. because his name is on it. But I assure you that it begins here in Jefferson County with our representative, our top prosecutor, the person who purports to represent all of the people, who's in there saying, I want an all-white jury. And whatever it moves you to do, whatever visceral response you have to this idea that a black defendant would be acquitted in our community by a jury of 8 whites and 4 blacks, and then after that is over, the top prosecutor in our city would go to the Supreme Court of the Commonwealth of Kentucky and claim that he was deprived of his all-white jury. For what purpose? One purpose. One purpose. It ain't going to help him in this case, but it's going to help him in all the other ones. And that is a despicable purpose. It is a repugnant purpose. And it shouldn't be in our community. So if you feel that way, if you have that visceral response, then I would urge you to communicate that to the individual who is doing this to our community.
Judge, we agree with you, it's repugnant. What do you, an email, a letter, Mr. Wine?
Yeah,
We've been talking
email
about
or letter.
this.
He is not accepting calls. Individuals have contacted me to say from all over this country that they have contacted him, and he's refusing calls and refusing to take messages. He's instructed his staff to refer them to a website in which he has a statement that he's indicated on the statement that the Supreme Court of the Commonwealth of Kentucky has certified the issue as if that is some kind of relief that they've bestowed upon him. People don't understand. And then he's on there talking about Judge Stevens implicitly. He's one of 200 judges. He's the only one who's ever done this. I wear it as a badge of honor. But does he wear it as a badge of honor? That he is the only prosecutor in the history of this country to have ever gone anywhere claiming I lost because I didn't have my all-white jury. He has a distinction that is far beyond mine. So I take my 1 in 200. I'm happy with it. I'm proud of it. But is he proud of his? Because he's going to have to own it. He's going to live in infamy. Did I answer your question?
Hey, Judge, may I take that question, take it to a level that's not personal between
Take
you and
it
Judge
all
Wine?
the way.
Even
Take it
though
all
I
the
did
way.
hear a rumor yesterday, you sua sponte had dismissed an all-white jury. I heard that at the courthouse, so I'll tell you about that later in private.
Okay.
That's
And the statement, just for everybody here, is that I sua sponte dismissed an all-white jury, and that is absolutely 100% false. And let me tell you why before I get to the rest of it.
Please.
Easy. What kind of judge would Judge Stevens be? The defendant is objecting, and I'm saying, no. I'm going to get rid of your jury. When he is convicted, what's the first, the last, and the only issue for appeal? Huh? Judge Stevens got rid of my jury. I wanted my jury. That jury convicted me. If you watch the tape, you will see. I said, you want this jury? You got this jury. You don't want it? I'm sustaining. It's yours. Your choice. So that is false, lie, pants on fire, lie.
Well, you know, he probably wasn't lying to me. That's probably what he heard. You know, I mean, he was mistaken.
Here's what I include anybody who's speaking on things that they don't know about, and they're making assertions. I call that a lie.
I'm glad I didn't repeat it anyway but you.
No, you said somebody else told you, so you gave it a little bit of cover. But all I'm saying is, if folks want to speak, if they want to say that about Judge Stevens, they should have reviewed the tape, because they're lying. And that's pants on fire. That's basic. You learned that in elementary school. If you don't tell the truth, your pants are on fire. You're lying, and that's exactly what was going on there. I did not, at any point in time, sua sponte, dismiss any jury. Lie.
So this young lady, as a civil practitioner, asks, I agree, an excellent question. When I talk about the law here in a little bit, I think I've got 15 cases in my materials. I think 13 or 14 of them are criminal. And as an almost exclusive criminal practitioner through the 90s and almost exclusive civil practitioner since then, for the last 25, 26 years, and see if you agree with me or if you've seen this with your brethren and sisters wearing black robes. it's vital that we convince the judges to exercise their discretion on voir dire and causal strikes in civil cases, and to convince them that our client's right to a fair trial is just as important in the civil context as in the criminal. Therefore, these cases have applicability, and we're going to talk about them all. But what I find is that judges are more attuned, or they're just more ready to exercise that discretion in criminal cases, because for some, somebody's liberty is more important than somebody else's money. And I understand that, but I think it's our job as civil practitioners to use these cases and say they apply across the board. But you see that difference,
I
level
do.
of discretion?
I do. I see it, and in my opinion, my humble opinion, that's all it is that there is a mistaken emphasis on the rights of the defendant and the rights of the litigants. Batson speaks to the right of the juror to participate in the process and not be discriminated against. And in that sense, it applies to civil cases as well as criminal cases. So if a jury pool is improperly constituted, then, and a motion's made, the focus of my inquiry, while I'm mindful of other factors, is the focus of the inquiry is the right of the juror to serve, to participate, serve, without being discriminated against. And I think we need to shift the concentration and understand Batson, which a lot of people don't. They don't want to understand it because it's uneasy, it's uncomfortable. You start talking about Batson, people start looking to the ground. It's like when I start my end of my criminal dockets, we have criminal motion hour, and then we have civil motion hour. But somebody strolls in late on the criminal docket, and all the criminal defense lawyers are gone, all the PDs are gone. And I remember just 2 weeks ago saying, is there any brave soul in here who will step up and do their duty for the Commonwealth and represent this individual? And I kept on for 5 minutes. Okay, I was, well, is there any single soul, just a brave person to do it, right, Sheriff?
Right.
And then somebody stepped forward, okay, and they did it. So there's an uneasiness about that because they don't know anything about it. There's an uneasiness about race and discussion of race and Batson because at the end of the day, you're saying that somebody acted in a racially motivated way, and you don't want to tell them that. You see these people all the time, you work with them, you know they're good people. They wouldn't do anything like that. I won't go, I've written on this. It is much more involved than us personalizing this. And in our small community, we tend to personalize a lot of things. We tend to not tell people when they're wrong because we're friends with them. We tend not to want to be out there publicly saying things about people because we like them. But there's certain things that are much more important than personal relationships when it comes to protection of our community and the rights of individuals to serve on juries in Jefferson County. It is that important. I don't have any friends as far as I'm concerned when it comes to that. If you're opposed to it, I'm opposed to it. Friendship is not going to get in the way. We can still get along just fine. I don't have anything, but I'm going to tell you, if you're wrong, you're wrong, because the stakes are too high for me to be quiet. And that's what I'm urging you to do. Anybody within the sound of my voice, I'll say it again. If you don't believe in this, if you want this, if you want something else for our community, then step up to the plate. If it's a letter, if it's a call, if it's a statement publicly, voice your position. Let it be known. Because I guarantee you this, I've already taken back through history. The people, we are on the side of right. We are on the side of right. History will judge us that way. But in anything that is done in history, there are always individuals who stand in the way of progress, who seek to impede progress, who want to hold the status quo. And those are the infamous people. We remember them too, the people who stood in the doorway of the schoolhouse. We remember them. The people who went in 2015 to the Kentucky Supreme Court saying, give me my all-white jury. difference between being famous and being infamous. Remember that. Did I answer your question?
You did, Terry.
Okay. Mr. Meyer, did I get?
No,
I guess yours is more of a
I
statement. I
remember
agree with you.
Lisa, who keeps putting up the order in which we do these CLEs. This is the second time I've had to follow you, and I don't remember Lisa's ass until I'm not following Olu Stevens anymore.
We have any other questions? No, we're going to get back. I'm relying upon you to bring this back to where it needs to be for these good folks to get their CLE and actually learn something that's help them practice their cases instead of being a community activist like Judge Stevens. You know, is there anything else? You all have been great. I know there's a lot of people, but thank you very much. I really, really appreciate your attention, and my hope is that we address this issue in a way that's beneficial for our community. We need this. We need to step up, and we do not need anyone in our community saying that we should have an all-white jury panel. Not in 2015. That's a challenge to you. I know I'm done about an hour, so I'm finished. Thank you.
Thank
very much. How do I order a copy of the tape? How do I get a copy of the tape?
It actually goes through an app right now.
Oh, is that right?
So
Oh
we'll-
gosh, times have changed. It goes through an app.
It all runs through the iPod.
Is that right?
Thank you.
10 years, man. 10 years. I don't know, man. I'm looking for some paper. I just want you to give me some paper. So, can you get back in touch with me about that? Just okay. Thank you.
Hey,
All right.
you got 3 minutes?
Yeah.
All right, here's my take on race relations at Olu's, come from the pulpit, and I'll get away from the bar for a minute. I was blessed to have parents who immigrated from Germany and grew up in post-war Germany, and his children during the war. And my grandfather was actually put in a concentration camp for 2 years for helping some Jewish people trying to get out of Hamburg. So when my parents came over here in '57 and saw the racial prejudice that was prevalent, they were horrified because they really thought they were coming to America where that bullshit didn't exist anymore. They thought they were getting away from those things. And so when my dad, Rolf Meinhardt, bought his first car in 1959, he bought it from a black man as a used car. And when he went back to work, he was showing the guys that he's working with the picture of this car, and he said, "That's worth it. It's a good car." And they found out it's a black guy's car. And he said, "You can't buy that. You can't buy a used car from an N-word guy." And he couldn't really afford the car, but he bought it anyway to make a statement. And that's bullshit. And so he bought that car, and that's the kind of way we were raised. So despite being raised by these wonderful people, and being horrified by any time you see something wrong racially, I'm still a white guy. And the love of my life right now is my 3-year-old biracial granddaughter. And who looks more African American than she does? Caucasian. And though I've always been horrified by rebel flags, I have to admit, at 52 years of age, 2 months ago, when I was on my boat with my granddaughter in my lap down Rough River, and some good old boys come by the other way in the rebel flag, and what we always do is wave at each other on boats down Rough River. It's the first time the rebel flag ever scared me. Because I thought, when Cadence gets older, this symbol is going to scare her. She's going to know what it means. And it's just, first time I ever felt like that. And I was a little bit ashamed that I hadn't felt that way before, even though we are left liberal family and raised the right way. But anyway, it's an evolving process. Maybe there we will. Say goodbye. All right, good to see you.
All right, good to see you.
Let's take a 5-minute break and let's talk about some law. Thank you.
Thanks, Michelle. Oh, my pleasure. Thank you very much. I appreciate the opportunity. Sorry, but if you do have questions about what I put in there, in the materials, please call me. And I promise you I will not preach to you anymore. I will answer your questions, your substantive legal questions about the matter at hand. Thank you. Thanks a lot. Appreciate your attention.
Appreciate it.
Yeah.
You have a chance to file a this week?
Yeah, we're working on it.
I think we should go to a oral argument.
Yeah.
That's probably what we should do.
Well, I'll tell you what, like I said, they put me in a position where, legally speaking, procedurally, if they had filed a writ against me, thank you very much. I appreciate your attention. If they had filed it, yeah, I'd be a party and I'd be screaming from the mountaintops. I'm screaming from the mountaintops now. I just decided that this is not an issue that's ever going to come back to me. This is not a case that's active. Like I said, it's done. It's completely done. And although I cannot be, I understand at least I can't be a party. I've been contacted by an individual who's going to represent me who believes that wholeheartedly I should be a party to this and can be. He's going to file a motion. So we are working very hard. And like I said, within 55 minutes here, I'm going to have a meeting, and hopefully the MBA will take some action as well. The NAACP Legal Defense Fund, we've contacted them. I haven't heard anything back. They've got a lot of cases, but my hope is that they'll become involved because this is an important issue. I see it as more important than Batson because we never reach Batson, as I indicated with the exception. So,
Could be a chance to make some good history.
well, that's what we want. We want good history. We want bad history. You know, that's the thing. That's the thing.
Yes, sir.
So, yeah, thank you so much.
Thank you, Judge. I appreciate it.
All right.
What's being done to prevent the 40 and 1 and 38 and 3?
We've been addressing that for roughly 15 straight years every month.
Yeah.
And what we do is we go through and say, hey, we need to get these numbers up. We need to get these numbers up. We need to get these numbers up. At some point, our efforts are good. They're always good. But again, our meetings and our reciting numbers and all this other stuff does not help the individual defendant who's facing that when he sits down in the courtroom and looks at the box. The question is, who has discretion to handle that outlier, to make sure who's the last line? That's what I say. Who's the last line of defense? And the last line of defense is the trial judge. It's me. I've got to make sure that that defendant gets a fair trial. And motion needs to be made. But I don't mind saying, based upon my 6 years of experience, 147 jury trial, and obviously I know what a properly composed, racially composed jury panel looks like, who it looks like. And if I see something that's really bad, I'm going to say something. And as I've indicated, it has very little to do with the race of the defendant, although that is practically speaking, that's a factor. I mean, let's just face it, it is not, they're addressing as best they can, trying to expand the pool, encourage people to go in jury service. And some of my colleagues have gone out and talked about jury service. They won't talk about this because it's uncomfortable. But this is the reality of what we're dealing with. It's easy to start telling people, oh, come on in and join us for jury. It's like it's some kind of party or something. And we try to make it inviting as we can. It's your duty to do it, and it is our obligation to make sure that it's open to everyone, regardless of your race, that we are bringing here everyone. So, 2 times that I said them down, I've always got back something out of it. It's not a problem. Judge, we can do this. And that's why I'm saying, him going to the Supreme Court, he's not fighting. He's wasting time. He's wasting effort. He's wasting money, and he's wasting our community goodwill, which we have. We can come together on this. We don't need to be a part of this. We can all be together. We want diverse juries. What's wrong with that? Nothing. Absolutely nothing. You should be for that. If you're for anything, you should be for that. If you're for justice and fairness, you're for that. And that's what I'm doing.
Thank you.
All right. No, thank you very much. Appreciate it. Sorry. All right. See you.
Judge, good day.
All right, you too. See you guys.
Oh, no, I don't know. No, I can.
Those two would be last.
Okay. Yeah. No, pronunciation.
Ready?
Good morning.
Good morning to you. Thanks for being here.
Absolutely. Thank you all for being here. It's the first time I've ever been asked to teach a seminar, and I probably taught, I don't know, a dozen of them. It wasn't in June, right up against us meeting our hours. So although it's a much smaller group than used to, it's kind of cool, I guess, because somebody actually wants to come here and talk about what deer, rather than just sit there and text and get their hours. My name's Chris Meinhardt. I'm an attorney from Louisville, Kentucky, born and raised here, and practiced here since I graduated law Civil practitioner,
Yep.
what's your name?
Kristen Fowler.
Good to see you again, Kristen.
Good to see you.
Your name?
Yep, Ashley.
Ashley, good to see you again.
Michelle.
Michelle? Hey, Elgin.
Hi.
Elgin's probably the only one in here who's been practicing a little longer than me. Civil or criminal?
Civil. Civil.
Okay. Like I said, I started doing criminal law out of the gate, and got the great honor, and I'm not saying that seriously, to start representing the outlaws in about 1995. And the little outlaws in the 90s were the Hells Angels of Kentucky, and they got in a lot of trouble, and I tried a ton of cases between 95 and 2002 because I was their go-to guy. And it was wonderful. These guys paid in cash. They took care of their own. They took care of the lawyers. And in 2001 and 2002, two things kind of happened simultaneously. Rex Dietz stabbed the owner of Babe Strip Joint. Rex was the president of the Outlaws, and he killed this guy, but they brought him back to life and went to the hospital. We tried that case within about a year of it happening. Rex got convicted of assault with one. He got an 18-year sentence, and the phone never rang again from the Outlaws. I was done. Not even a speeding ticket. And that was fine. I think I won 17 trials in a row, meaning beat the offer, not necessarily acquittals, but a lot of acquittals and all beating the offer. And also dovetailing with that, two lawyers named Guy Hibbs and Harry O'Donnell had a medical malpractice wrongful death case, and they asked me if I would step up and try the case for them. They couldn't get it resolved against Byron Miller and Todd Thompson, two very good, great medical malpractice defense lawyers. I'd never tried a car wreck case to that point, and I got my ass handed to me. We went to the Supreme Court on an appellate issue in front of Judge Wine, actually, and you heard his name. And the Supreme Court sent it back. And within 18 months, we tried that case twice, and I got my ass handed to me again. And I said, "The heck with this!" But I was smitten, and I loved it. I loved the challenge. I've pretty much been doing medical malpractice cases since then. My private practice, I also hold public office. It takes a lot of time. So that's me. Didn't plan on starting this way, but I will disagree with Judge Stevens. I'm glad he's gone. On one thing, I will agree that Batson stands for the juror's right to be treated fairly, but I don't think that's really the most important part of voir dire. I think your defendant's right in a criminal case and your client's right in a civil case trumps the juror's right as far as voir dire goes, and that's what our job is. Let's get outside that trial. And you want to advocate for whatever you want to advocate, great. But during that trial in voir dire, your job is to make sure, to the extent you can, that you sit 12 people that are as favorable to your client as possible. And although Batson does talk about that, who knows who Joe Gutman is? You all know who Joe Gutman is?
Yeah.
I know you do. So that's kind of dating who we are, okay? Joe was the golden boy of the Commonwealth Attorney's Office throughout the late 80s and 90s, and he quit practicing law 15 years ago.
Yeah.
He teaches at Central High School. He teaches a law government class, and he and I are working on a project with Special Olympics. He was in the office last night with some other people, Judge Delahaney and some others, and he told me that just this last month was a 30-year anniversary of Batson. And a few months ago, he was teaching at his high school at Central, and great law government program he teaches there. And they called up to his classroom and said, "There's a man here, there's a gentleman down here to see you." He said, "Well, you know, what's his name?" And he said, "Well, he says you all go way back." And he said, "Well," and Joe, he prosecuted all the bad guys, the murderers, the rapists, the big drug kingpins. Joe was their golden boy for years and years, and a very talented prosecutor, and burned out accordingly. He said, "Well, all the more reason to find out who it is." And he said, "It's James Batson." And he said, "Well, send him up." So Mr. Batson, who had been convicted in that case, and then got overturned, and Joe became friends, and he came to visit Joe and in school, and they are teaching now on a circuit about Batson. And if you get on the internet and look it up, you can find it. I encourage you to see it. It's pretty cool. What Joe said last night kind of dovetails into my disagreement with Judge Stevens, respectfully. What he said to me was pretty telling, and it goes into the way I want to teach this next 40 minutes or so about the way I conduct voir dire and the way I view it and what our jobs are as civil lawyers. I'm not a civil lawyer, and I'm glad I'm talking to mostly civil lawyers. Joe said, you know, the Supreme Court only got it half right. Not only is it a racial issue, but they should have just got away with preemptory challenges right then and there, and just because that is nothing but innate prejudice. I don't like that tack. It might not be racial prejudice. I don't want school teachers. I don't want pilots. I hear all this crazy talk about these pundits on who makes a good juror for your client based on occupation and things like that. I don't believe any of it. But he said they should have done away with preemptories and expanded the judge's discretion on causal strikes. And it just struck me, the meeting was getting ready to start, so I didn't really tell Joe. I said, Joe, that's just so ironic. You would say that as the guy who led the Commonwealth Attorney's Office, Jefferson County, for all these years. They've got the discretion. The law gives them an abundant amount of discretion to strike jurors for cause. They just don't know it. Tried a case in front of Judy, and so we're going to concentrate on a couple cases. My topic is to teach the law on voir dire, and I've given you 14, 15 cases. They're at the very back of your materials. Don't worry about going to them. The sites are there. My snippets for what I think is important there. But what I really want to do is talk about how we use this law in voir dire to get as many people struck from the panel as possible that we think exhibit the slightest amount of bias or prejudice towards our client's cause. And the first two cases are Montgomery, and the other reason I want to come here and list the dates. And Montgomery is a 1992 case. Almost all these cases are criminal. And just like that, so that's a great question. They absolutely have civil applicability. And what you need to do as we talk about these cases, you need to let these judges know as quickly as possible what your arguments are going to be during voir dire. In my case, what I usually do now is let the judge know beforehand, before voir dire. Because if I get an answer from this prospective juror that I don't like, and I think they're equivocating a little bit, we'll get into the details of this case and why I think that's important, and I go to argue that that gentleman should be struck for cause, I don't want that to be the first time Judge Stevens has read Montgomery or these cases. So in a pretrial memorandum, in a motion to limit, I've done it many different ways. I'm Chris at bluegrassjustice.com. If anybody's interested in getting the procedural vehicles by which I bring this court's attention, just email me, Chris at bluegrassjustice.com. I'm glad to help you out. If anybody's getting ready for jury trial and thinks they might want to adopt some of this strategy, please call me. You can come to my office, and I'll come to your office. I love doing it. I don't want a piece of the action, but I will certainly help you go through a template, some prospective questions. Because the first few times I tried it, I really did butcher it, and I don't think I did my client service. The last few times I've tried it, I really think it has helped us get some pretty nice verdicts. I tried a case in Bowling Green this year in front of Steve Wilson, and the jury was hung 7-5 in our favor. In a medical malpractice case, that's extremely rare. You just don't get hung juries very often in civil cases, especially medical malpractice cases. But that's what happened. I had tried a case in Bowling Green in front of Judge Wilson 2 years ago. We got a pretty nice verdict against Dr. Slaughterback on behalf of Toby Crocker. In that first case, I had not told Judge Wilson about these cases. I did not told him what I planned on doing during voir dire, and he was not very receptive to my calls and strike motions, and he didn't strike any of those people. It was a good case, and we got a verdict in. This time he was prepared for that, and he actually told me during pretrial, you know, you should have prepped me last time, because I'm not all the way on board, but I'm certainly more receptive to some of the things you're trying to do here. And he struck, I think, 7 or 8 potential jurors that I didn't think would be good for our case. Now, go aside and tell you a war story, and I'll come back to it. In that case, it was a case against an orthopedic surgeon for botched knee replacement surgery. His patient was a lawyer. John Donnelly's a client of mine. He's a lawyer down in Bowling Green. if I had known the percentage likelihood of winning a medical malpractice case with a lawyer as a plaintiff, I never would have taken the case. I said, John, we have less than 1/10 of 1% case because that's the percentage of jury plaintiff's verdicts that come out of that dynamic. So I felt thrilled that we got 75 on the jury. But Mr. Franklin was the elder statesman of the jurors. He was in his 70s, very sharp man, very nice. On a Friday at lunchtime, they go out, and about 3 o'clock, 4 o'clock, 5 o'clock, they're sending back questions. Judge Wilson, who's an awesome judge, a past prosecutor, is answering some he can't answer. We're getting heated battles between David Broderick, who's a great defense lawyer, owns that town down there, and about 7 o'clock at night, they hang. And so they worked really hard on a Friday. They didn't want to hang, they wanted to work hard. So we knew that they were hung 7 to 5, but we didn't know in whose favor. I asked the judge, like I always do in front of the jury, because a lot of judges want to protect their jurors from lawyers. Olu's the worst. He wants to protect those jurors because of lawyers. So I always do it in front of the judge to kind of put him on the spot. Judge, do you mind if I stick around and do an exit poll with these jurors? So they know that I want to stick around and talk to them. And Judge Wilson was very accommodating. He said, here's what you're going to do. You're going to go back in my chambers. I'm going to take them back to the room next to my chambers, and you'll see them file out. And whoever wants to stick around and talk to you is welcome to it. It was 7:30 at night by the time on Friday. I knew they just wanted to get home. So he's back there talking to them for about 10 minutes. And Mr. Franklin, who's outspoken and said, he said, Judge Wilson, I'm done talking to you. I want to go find Meinhardt. Wilson tells me, he said this afterwards. Franklin walks out, and he says, fine, go. He talks to the other 11. Mr. Franklin comes over to me. I'm standing there. Mr. Meinhardt grabs my hand with both hands. He says, and he just starts saying these things like, I just want to tell you, from this minute you started talking jury selection, like father, I connected with you. This sounds hokey, but I felt like we're brothers. I just can't tell you how much we all respected your behavior in the courtroom, and on and on and on. And I said, Mr. Franklin, thank you so much for all those kind of words. Whose favor were we in at 7 to 5? Because I thought it was going to have a significant effect on how we were going to go from there and negotiate when we settled the case. We have not settled the case. We tried again in April, March. He said, oh, your favor, 7 to 5. He said, in fact, at one point it was 8 to 4. As a civil lawyers know, you only need 9 to win. I said, damn, it was 8 to 4? And he said, yeah, and then they wanted me to talk and say my piece. And I said, you couldn't get one more to swing over? And he said, oh yeah, that's what got it to be 7 to 5. I said, Mr. Franklin, are you on my side or their side? Oh, their side for sure. I just think you are great. and Ethan Manning, my young associate in the second chair, just started busting out laughing. He couldn't stand anymore because we were all slap happy in 2 weeks of time. So the reason I tell that war story is I see seasoned veterans go into voir dire and try to schmooze potential jurors. Canned questions. Let's just get this uncomfortable session out of the way, get to the trial, get to the evidence, because I don't know what the hell I'm going to do, and I don't know how to get jurors struck for cause. Quit doing that stuff. Get in there and get down to business and try to elicit answers to particular questions that will surface bias, that will lead to, if not a causal strike, at least an intelligent exercise of preemptory. And so that's what I want to kind of tell you guys to do. So apparently I schmoozed him over, but I never got him to tell me what I needed to tell me, so I failed. Vance and Gutzman, civil criminal applicability. Skip the local rule stuff. The only reason I put that in there is, and I'll get right to Montgomery, these other cases here in just a minute, is if you do try a case out of county, and I've tried them all over the state, God, get somebody local, read the local rules. The first time I tried one in Owensboro, we got the juror information sheets. That's another thing. Out in the county, sometimes, out in the state, you get your information sheet weeks, if not months in advance. And you can sit down with local counsel and say, all right, tell me who this Michelle Green lady is. You know, who's she related to, who does she know, stuff like that. We can't do that here. We get them handed to us as we know the day of trial. That's one advantage. There's so many advantages. But my co-counsel and I saw that these things were in alphabetical order. And we know, with trying to make a case in Jefferson County, that they're going to pull people. Who's tried a case in Jefferson County? Okay. Who's tried a case outside Jefferson County? All right. There's a substantial difference in the way jury selection is conducted in Jefferson County than the rest of the state as I know it. There may be some other counties that do the way we do. Ours is wonderful. We fill up this courtroom with 50, 60 prospective jurors, and we get to talk to all of them at the same time. Out in the state, they will bring 12. 2 more if you've got 2 alternates, 14. If it's 4 peremptories apiece, that's 8 more if you only have 2 clients. And that's 22 people, and they bring 22 people up, sit them, and those are the only ones to get to answer your question. Everybody else in the courtroom is supposed to be listening, and remember, if they fill up one of these seats because it calls a strike or a strike for some other reason, and then say, did you listen to all those questions? It sucks out in the state. It does for
You like the Jefferson County way.
There's no question, if you want to engage jurors and get them talking to you in the way I do it, this is a Jefferson County style, it just is so hard to get that going out in the state. Because what I do is I try to find somebody who is fundamentally opposed to some bedrock proposition I have, whether that is we're entitled to pain and suffering, or if it's a criminal case, the Fifth Amendment is a privilege that has to be honored, and there's different bedrock themes. And you get somebody just to equivocate a little bit and say, I'm not sure I agree with that, I'm not sure you're on an even playing field. And then you get other people to identify with that person versus this person. I explain that a little bit. It's so difficult to do when you only have 22, 24. And they know, they don't want to be picked on, so when they fill that seat, they're not going to raise that hand and be that person. So, and there is a movement afoot to get Jefferson County in line with the rest of the state. It still is afoot. So what do these cases say? What does it mean? The local story down in Owensboro was, we sat there, we got the sheets the night before, as quick as we get them, we got them out of the alphabetical order they were in and put them in numerical order because we knew it would be easier to identify which juror as they brought them up and sat them in the seats, because we know from practice in Jefferson County, Olu's worst, how the courts here really like to protect the anonymity of the prospective juror, and we refer to them by numbers and not name. And we are not to identify somebody and say, Miss Eve, let me talk to you about this. Let's talk a little further about what you said. I'd be damned if the first juror isn't called and the bailiff says, all right, seat 1, Elgin, Mr. Crowell, take that seat. Seat 2, Kristen Fowler, that's your seat. And I'm like, what the hell? Because I hadn't had a local lawyer down there, they knew everybody. Everybody knew everybody. They didn't care, and they used names. So I've got all mine in numerical order, and they're on the other side. They got theirs in alphabetical order. So that and this last trial against David Broderick, there was a nurse on board, and the doctor's name, John Byrne. I had actually settled a case with Dr. Byrne, who caused the lady to lose. He's a butcher, but God does he present what was handsome, he's articulate, deacon at the freaking Burning River Baptist Church and stuff down there. And but I had settled this case against him 2 years prior, where he had severed this lady's arterial, femoral artery. I think femoral artery he severed, and she bled out. And despite the fact that the nurses were calling him post-operatively, saying her foot is blue, there's a knee replacement, she's complaining of pain, blah, 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 all the telltale signs of vascular insult. He said, put a blanket on her, she's fine. He didn't come back. By the time he did his rounds the next morning, it was too late. The vascular surgeon couldn't save the day. She lost her leg on a knee replacement. They had to settle that case, and we settled for a good number. So Dr. Byrne doesn't like Chris Manor. Well, we're suing again. This is on behalf of John Donnelly. This one's going to trial. And that he has had 2 dings, mine and another one, so he can't afford a 3rd ding because he can't get insurance if he does. So he's going to trial. And so he hung the jury. He's still alive. He's still practicing. On the panel, and despite the fact that I had local counsel help me with all of the profiles, they didn't sit in voir dire with me. And there was little Miss Michelle Green. Green Michelle? And very nice, but hell, Michelle Green works at the same hospital as Dr. Byrne, and she's a nurse, and so she's not sitting on my jury, right? So we go through everything. I don't really even ask her any questions because I'm painting with a broad brush. You should know better. And so we do our exercise, our preemptories, and damn, both sides struck Michelle Green. And after the trial, I asked David, I said, why did you? He said, she was on the team on your other case. She was one of those nurses that called Dr. Burns and told her to come back, you dumbass. I didn't remember those medical records. I can't remember the medical records I read yesterday. She knew what an idiot Dr. Burns is. She works with him all the time. And so anyway, that could have cut both ways. You never know. But it just was a lesson of local knowledge.
Did Michelle Green, you know, when the judge says, here's Chris Meinhardt, does anybody know Chris Meinhardt? Here's Dr. Byrne, does anybody know Dr. Did she not say, yeah, I know Dr. Byrne?
I think she did, and I think we had already identified the fact that she worked at that hospital, and he certainly didn't ask any of you worked with her, and I don't want to ask questions and something like that I think I'm going to strike if I think they're saying, yes, I've worked with Dr. Byrne for 40 years, he was a great doctor, you know, because that kind of stuff comes out too, so I'm just staying away from her. So it was just a lesson.
You were just a striker. Yeah.
So it was all right. About halfway through, so let's talk about, you know, and so here's Judy McDonald's a dear friend. You know, we went to law school together, played volleyball together for years in leagues and stuff, and her kids and my kids hung out some, blah, blah, blah. So anyway, the background is we're good friends. Tried a case in front of her 3 years ago, and she took the break. And she said, I'm going to go back and read these cases. And she said, Chris, that's about when I took the bench. I've never heard of this case. And it's the Montgomery case. And because I was trying to argue to her that what Montgomery stands for is that judges need to remove rehabilitation from their lexicon. There should be no rehabilitation efforts whatsoever anymore from Montgomery 92. People have been trying to rehabilitate witnesses day in and day out, and they're doing it right now over there in jury trial. Now, all these cases are criminal, but all these cases have been declared reversible error. Now, all you have to do is say reversible error 3 or 4 times from a judge, you finally get their freaking attention because they don't want to come back and do this again. And you need to empower them that these cases tell them, slightest bit of equivocation, you don't let anybody try to rehabilitate them, you strike them. There is such a mindset from some judges whose names will remain unspoken, like Olu Stevens, to protect these jurors from these bully lawyers that we might embarrass them a little bit. Screw that. You know what? So what if they walk away a little bit bruised? And I'm not going to do it to the extent that I embarrass them. They may stay on the jury and poison me. I look like an ass in front of the other 12 that sit there. We're not going to do it that abrasively, but you got to be able to talk to them. And if it's an offensive thing, it's an offensive thing. So anyway, so here's, in the Montgomery case, it was out of state. It was a media coverage, high-profile case, and that's what it was all about. The issue is that people had any predisposed conceptions or premonitions about this case based on what they'd heard in the media. 5 inmates had escaped. They killed a couple of innocent citizens. Ton of coverage, and they were 4 of the jurors said they were familiar with the case and they read some of the stuff and that they had formed certain opinions about the case, but then they were asked the magic question, and the rehabilitation question is called the magic question. It's something like this, but you've all heard it, that can you put aside your personal views, your knowledge, your preconceptions, your opinions, and decide the case based solely on the evidence and instruction? Well, in seasoned trial lawyers will still ask that stupid-ass question. And it's so bad because if you've got somebody coming out and saying something that's just a little bit one-sided, tells you that you're just a little bit behind the eight ball based on some preconception, some bias they have, that is enough to argue the judge to strike them. If you ask them that rehabilitation question, 99.9% of people they're going to say, yeah, I can do that. Yeah, I can put aside my biases. If they have biases and they voice those, that's enough to get them struck. So don't ask the magic question anymore because they're going to be rehabilitated. Go ahead.
What if you don't ask if the judge does? And then how do you?
What you do is, that's why you give them a copy of Montgomery and you highlight this section before the trial. The Supreme Court of Kentucky in 1992, and Montgomery is cited again by McDaniels in 2011, which is a stronger opinion because it's a weaker statement made by the jurors. And in this case, what the Supreme Court says directly to the trial court judges, the concept of rehabilitation is a misnomer in the context of voir dire. Trial judges should remove it from their thinking and strike it from their lexicon. That's a verbatim from that case. 9 out of 10 judges have never heard that statement and certainly don't abide by it. Don't let the other side do it. Don't let the other side try to rehabilitate. Get up there to the bench on white noise the first time it comes out and have the judge prep for that. Okay? It goes on to say that you don't even have to have a statement exhibiting bias. You don't have to have an actual admission. You can infer implied or reasonable probability of bias based on somebody's association, based on something else they said. They don't have to come out and say it would be difficult or blah, blah, blah. So you can take it as far as you want. Most judges aren't going to go that far. So what, I'll keep going down my outline because I've worked on this a few times. There are different elements Montgomery tells the court to look at. Do they say they're partial to one side or the other? And it can be 51%. The totality of the circumstances. So you go up there and you argue, well, you know what? She said that she's not for tort reform. She said that she's married to a doctor, but even before I could, she said she'd be fair. Judge, the totality of the circumstances of that is she comes in with such biases against medical malpractice litigation, she should be struck. That has been successful. What you have to do is convince the judge that this age-old exercise, this age-old epidemic of not exercising their discretion is the actual 100% opposite of what they should be doing. We have a ton of prospective jurors out there. Let's get as an unbiased, neutral panel out there as we possibly can so there is no reversible error. The opposition cannot cite you to one freaking case that has been reversed because a judge struck someone for cause. I can cite you to 15 that have been reversed because a judge wouldn't strike somebody for cause. So that's the McDaniels case was a murder case. Somebody knew, one of the prospective jurors knew the victim's widow and just expressed the fact that it might be somewhat uncomfortable. Now that's not bias. That's just that it might be uncomfortable because I know the victim. What McDaniels stands for is equivocation. If you can argue to the court that on the issue of impartiality, equivocation, this is quote, equivocation on impartiality simply is not sustainable. And again, it came back and that person was rehabilitated despite the fact that you knew the victim, despite the fact that it might be uncomfortable, can you be fair? They cited Montgomery and said, quit letting them rehabilitate. Once they say something, even if it's an equivocation statement, that says that implies they might be biased once that get rid of their ass. It also uses the term level playing field. If the court seats a jury in which both sides are not on a level playing field at the beginning, the court has abused its discretion. That's a quote. So I use that term, level playing field, in my questions. Hey, Ken?
Hey, Chris.
So what I will do is, if I get someone who's a nurse, I get someone who's, you know, he's married to a doctor because his doctor is this great trauma doc. It's okay. His wife is a great trauma doc or whatever. If I get somebody who admits that they think they're runaway verdicts, you know, I've got all these core concepts. I said, the fact that you know, you think juries in our country are awarding too much money and runaway juries, the fact that you believe that, and I respect that because everybody's raised their hand, those people raised their hand, the fact that you believe that, and I respect that, you know, does that mean that I'm just a little bit less than an equal playing field? Just a little bit? Boy, if I can get them to say that, okay, if I get Ashley to admit that, she should be struck. After she says that, who else in here agrees with Ashley? Hopefully I can get Elgin over here to raise his hand. Who doesn't feel that way? Who thinks that way? It's absolutely equal. Okay, who agrees with Elgin and who agrees with Ashley? And then I have Ethan over here marking down everyone that raises their hand with Ashley. Now the problem with doing it on the state is they want you to approach and make your causal each time there is an objectionable answer, and that's just hard to do. You lose your train of thought, it's offensive to the jurors, but you got to do it that way. It's a lot easier in Jefferson County. That's why this works better in Jefferson County, because you can wait, let the jurors leave, and you can argue from your table. How do you get people to raise their hands? This happened in front of Judge Conrad in Olu County. It's the first time I didn't get everyone to raise their hands. McKay Shaman, who's practicing in front of McKay? All right. McKay and I go back to Little League football. Now, I came from over those little bitty houses behind Bowman Field. We lost dad, and mom was a single mother, immigrant family money. He came from Cherokee Gardens. We met at Seneca Park, where we both played for the St. Matthew's Rams. We didn't like each other then, we don't like each other now. But we tried cases against each other, and he was a badass prosecutor. He's the funniest guy in the courthouse, just ask him. And he is. He's got such wit, he's so intelligent, but he's a control freak. But man, could he get people to raise their hands. I've never seen anybody conduct voir dire as well as McKay Shaman. And if you ever get, he has come and spoke at my law school class when I do voir dire at McKay, come talk to him. He's got this A-E-I-O-U, and sometimes Y. Sometimes it means that the other vowels don't work, yank their ass off. But he can get people to raise their hands. I had trouble doing that. I adopted something from Rob Mattingly, who I have to give a lot of credit to, because Rob and I have been working on this stuff together for 5 years, and the lion's share of this is his research, and then I plagiarized it, adopted it, and probably implemented it. But Rob will tell a joke from the get-go. And so what I do is, the first thing that comes out of my mouth, it seems a little bit unprofessional, but it seems to work, so I do it. When I take the podium, and before I say, hello, my name is Chris Miner, thank you for being here, and stuff like that, first thing in my mouth is, a guy walks into a bar. He sits down, the bartender's there, he says, you know what, I think all lawyers are assholes. And usually I'll say jerks, because I don't want to cuss right out of the beginning. So the guy says, bartender, all lawyers are jerks. The guy down there in the other stool says, hey buddy, I take offense to that. He says, what are you, a lawyer? He says, no, I'm a jerk. So that, you know, it's a little bit self-deprecation. You've got a lawyer, I'm telling a lawyer joke, but I said, who here's heard a lawyer joke? Who here's heard a lawyer joke? You never heard a lawyer joke? Have you ever heard a lawyer joke, sir? All right, I need you to raise your hand if you've heard a lawyer joke. And that's how I just get people to start raising their hands. I swear, in front of Judge Conrad in Olu County, this young girl who had earrings down her hair and tats on her neck, did not want to be there, would not raise her hand. I said, really, you've never heard a lawyer joke? Not from your parents or anything? She sat there. So, but it usually works, and so then, I'll explain, because I stole that from McKay, is because it's very difficult right now to express to you all how much I need you to talk to me. It's the only time during the next few days, 2 weeks, whatever it is, that you'll actually have the opportunity to ask me questions. And I don't want you regretting it. So I want you to start raising your hands and get used to that and get comfortable speaking to me right now, because it really is important. Because here's my job. My job is to try to figure out who's going to be the most fair jury to my client. And they seem to appreciate that, and they seem to say, okay, that's what you're doing, okay? So the other thing I'll do is, then I say, so let me show you, let me tell you what I've got to work with. Because let's reverse roles. Let's pretend that you are representing little Johnny Rotten here. And I'm a prospective juror. You know what you know about me? My name's Chris Meinhardt. I'm a lawyer. I got 6 daughters, age range from 14 to 27. My wife works with me at the office. I've been involved in lots of litigation. Like you, I'm over 18. I'm not a convicted felon. Guess what? That's all you know. Am I a good juror for you? You don't know, do you? Well, that's all I know about you folks. So I need to know some more. So it kind of personalizes the fact that they've gone through this stupid process of having to fill out personal information, being drug off their jobs, and you kind of talk about the fact you appreciate that for their $12 a day. All right, so back to the case law. How we doing? You know what? This has been a real monologue. You guys jump in whenever you have a question or comment or a war story and give me a break to sip some water. Olu was special this morning, Ken.
I'm sorry I missed it.
Whoa.
Was he?
I was here for the last 10 minutes.
Yeah.
And
Yeah.
and he was on his soapbox. Boy.
I'm sorry I missed it. I'm sure he'd do it for me again.
He would do it in a heartbeat.
He'll buy you a copy.
And I repeated a rumor that I heard at the courthouse just yesterday.
Yeah.
That was false rumor, and he basically called me a liar. I said, "Well, I'm only repeating it to you." You know, he is something else.
Yeah.
But you don't have to follow him, so you got that going for you. So those are the 2 main cases that I really like you guys to look at and read and try and adopt those quotes from. The quotes are in my little outline, and that's the Montgomery and the McDaniels. What we have to do, though, and if you ever try to implement this, or no matter what you do, if you ever make a motion for cause and it's overruled, if you don't certify that in some way, it's all for naught. The courts will not reverse it if you don't certify it. There's a number of different ways to do it. You can do it on the record up on white noise verbally, but what I do is when they give you a strike sheet and they've got all those jurors, those 22 jurors, whatever it is, and they got the plaintiff's column, I said, here are my preempts right here, but here's who I would have struck, okay, if you had granted those other ones. And the judge's like, what are you doing in my strike sheet? You're just supposed to be marking. I said, Judge, here's the one I'm exercising.
Oh, that's good tactic.
Here's the one I would have exercised. Here's the ones I would have struck if you would have struck these other ones for cause, which I think you should have. And that way it's absolutely preserved in the record. And so if you don't do that, all these arguments are going to fall on deaf ears because they don't know if you would have struck.
Is there any difference with that preserving for appeal in Jefferson County versus out in the state? The timing of how it works?
Not good. Other than the timing of when you make your causal strike motions, you know, having to approach the bench while they're sitting right there next to you, and it's so obvious. What's your name?
Chris.
Chris, I can remember that. So if I want to strike Chris, okay, that's somewhat offensive. You know, it just is, because I don't like Chris for my client. So I might be wrong, and I've been wrong 100, well not 100 times, but I don't know if I've tried 100 cases, but close to it. But I've been wrong dozens of times. The Toby Proctor verdict, which was $2,017,000, because we asked for $2,017,000. It was one of those classic things where pigs get fat, hogs get slaughtered. I wish I'd asked for more. They were out 30 minutes. We knew we had lost the case. It had been over a week on trial. The judge was giving my client a very nice, well-intended, well-received speech about how hard your lawyers work for you, because we all know we've lost. And they come back to the one, they give it to the penny on basketball, like half an hour deliberation, and everybody's jaw dropped. The one who didn't vote for us was an elderly lady who I knew I had in my pocket the whole time. And not only did she not vote for us, she stood up and said, I am not part of this verdict. and she wanted the world to know it. And the judge said, we know. But if I want Chris struck, it's so much easier to make your arguments when you're outside the room. I can talk about you, and I can talk about your demeanor, and you know, you're obviously Hitler youth, and all these terrible things about you that I want to say to the judge in this totality of circumstances argument. Did you see how warm and fuzzy he was to defense counsel? And, you know, he didn't want to answer any of my questions, but when he did, Judge, here's what he said, and that's inherent bias. I can't do that on the fly with him standing 15 feet away from me. But it is what it is. But I don't know if that's your question. As far as the timing of preserving for appeal, no, I think as long as you get it in during the trial, you're fine. And I think the most simple way to do it is a strike sheet.
But you've got to get it before they like removal, before they draw people.
I don't think you need it. I think as long as it's clear that you've made the motions on those particular jurors and they've been overruled, it's preserved as long as you have identified which jurors it was. If you just go up there and say, I think these three should be struck, and they're not overruled, and your motions are overruled and they are not struck, it's a little bit fuzzy then when you when you use your preemptories. The judge, the appellate courts don't know that there's somebody sitting on that jury that you would have struck necessarily unless you make that clear correctly.
Right.
Sorry, beat that up some.
Another question from a trial novice. When you say you can also certify the question apart from identifying who you would strike on the sheet, how would you do that?
Well, I mean, you can tender a written pleading that certification of these or the jurors that I would have struck. And certifying the question really is a kind of an archaic term that's used more so in depositions.
Yeah.
To add emphasis to something that I've never seen it carry any weight in the courtroom. Kent, have you? A certified question?
No.
Okay, so I mean, it's just, when I say certified, I'm talking about for appellate, give them something that when you file your notice of appeal, then you perfect your notice of appeal, give them something they can go right to, which is that document. Not go back and review the record and try to guess which ones you would have struck. And the second case, the McDaniel's case, really talks about that you better preserve it. The core concepts that you start talking to prospective jurors about, that you're hoping they will latch onto and agree that they bring in some level of inherent bias that's going to get them struck for cause, in a criminal nature are pretty easy. You know, presumption of innocence, burden of proof. There's some cases in there about what you can and can't do on defining and describing burden of proof. I'd really like to push the envelope on that legally on both the criminal and civil cases. We can get to that if we have time. In the civil case, they're a little bit dicier because tort reform, runaway jury verdicts, asking for pain and money for pain and suffering, monetary compensation for pain and suffering. They really are topics that a lot of people don't like. A lot of people don't like lawyers. A lot of people don't like litigation. We're a very litigious society. So you got to be careful about how far you go with that. And sometimes it's just not going anywhere, and I move on. But sometimes I actually get some people talking about it. What I'll do with pain and suffering, if everybody wants to use it, it seems to work as well as any of them, is I talk about my dad. And I talk about my dad being an immigrant, because people seem to like first-generation Americans, first one ever go to college, and things like that. They like the fact that I got 6 daughters. They feel sorry for me. So you want to be self-deprecating. You want to tell the truth. And my dad was a tool die maker, and he did die when we were young, and he was a badass, and he did live through some very times in Germany. And I was going to law school when he passed, and we never had anybody go to college, much less go to graduate school. He could not believe I was going to be a lawyer. I mean, he thought the concept of pain and suffering was the stupidest freaking thing. His toes were curled up like this because my dad was 6'3", and his 2 brothers who fought in the war were much smaller, and he had to wear their shoes because they couldn't afford shoes. And his toes were permanently curled up like that. He had a size 11 shoe, but he should have been like a 14. He suffered. Somebody coming in and asking for money for pain and suffering, it just was such a foreign concept to him. Well, that's a kind of a cool story, right? Then you say, who feels like my dad does about my client coming in and asking for money?
Yeah, that's a nice way of humanizing.
It does. It's something that I believe in it, but somebody as close to me as my father did it, and I respect that. And I respect that, Mr. Westbury. If you agree with my father, thank you very much. The fact that you feel that way, I respect it. would you go so far, would you help me out here and understand that maybe that puts me on just a little bit less of a level playing field than Mr. Broderick here that's representing Dr. Byrne? And if you say yes, I got you. And I said, who here agrees with Mr. Westbury? Or juror number 1107 from Jefferson County. And if they raise their hands, then Ethan does my arguing on causal strikes. Because it's very difficult to take the notes and appreciate what people are saying and converse at the same time. So I always have a second chair that's got the grid, that's marking things down. And there's, voir dire is just the most underappreciated, underutilized tool we have. So many lawyers just want to get it over with and get through it. I mean, it's so vital and so important, but to me, it's the most enjoyable. It really is. It separates the girls from the women, because what you don't get to shoot from the hip. Even on cross-examination of a hostile witness, at least you've got an outline.
Right.
You don't know what the hell the prospective juror is going to say. And it really is a lot more fun if you like that kind of stuff. And that's trial lawyers should. So anyway, I really try to talk and not take notes. And if I'm asking Chris a question and he answers in a way I don't like, and I stop and mark down a big black X next to the name, he's going to chill out. It's just there's something offensive, and you see lawyers do that. If Ethan's over here writing the whole time, he doesn't know that. And so it's just a much perspective. And Ethan's smarter than I am. He can articulate arguments a lot better than I do to the judge, and I tend to piss off the black robes. And Ethan's very nice and soft-spoken, so it's a better way to do it. If you can find Ethan, you can't have mine. The other argument that Ethan used, and it came from the Montgomery case, because the Montgomery case is so strong in its language that the courts need to strike from the lexicon and its misnomer. He's the fact. Forget what that juror said, Judge. The fact that Mr. Broderick tried to rehabilitate him goes to Montgomery. That even Mr. Broderick agrees that juror exhibited an inherent bias that is against my client, and that he attempted to do it. Yes, you stopped him once we get it. That right there is proof in the pudding. The defense is agreeing there's some type of bias that needed to be retracted. I thought, way to go. It's a great way to argue that. And I don't remember if we got that guy struck or not. The Humble case is a Fifth Amendment case. For those who do criminal work, I did this early on in my criminal cases. A prospective juror said it would be tough to find the defendant not guilty if he didn't testify, but I think I could. That's plenty. All right, that's just plenty. That's bias. So the facts of these cases aren't near as important as what the court says in reference to. That's more than equivocation. That's the fact that he doesn't respect the Fifth Amendment. But if you ever represent somebody on a criminal case and you think they're not, whether you think they're going to take the stand or not. I'll still do some criminal cases. We tried the Davidson case against Chris Hutchinson about 5 years ago, and Davidson came down from Chicago, African-American young man, was going down 64 the wrong way on Derby morning after being out all night on Derby Eve. He killed 2 people and seriously maimed Mrs. Hutchinson was the prosecutor. I forget her name. I apologize to you, lady. She was second in command at Home of the Innocents, and she had to give up her special needs child that she'd adopted because she could no longer take care of him because of the brain injury and physical injury she sustained. It was just a horrific case. And I didn't want Brian to testify. Brian was a 2-time loser, so he had been a convicted felon twice. That will come out if he takes a stand. He was not very bright. He was sweet as days long. And he served his sentence. He got out last year, last 4 years. So what I would do in voir dire, if your client's not going to take the stand, you need to get that out, and you need to find out who's going to hold that against him, like this lawyer did in Humble, yet the judge still didn't strike that juror. That's pretty obvious, and like I said, in criminal cases, the judges are much more apt to exercise their discretion. But what I would do, which is probably inappropriate, screw it, let them call you on it, is I'll say, everyone here has heard of the Fifth Amendment. Everyone knows that Brian, always first name, is my client. It's always Dr. or Mr. on the other side. everyone knows that Brian has the right not to testify. And it's going to be tough. Who here wants to have all the information they possibly can have in this case before they render a verdict? Well, we all do, right? Right? And you don't even raise your hand because I know you do. If you're going to sit on this jury, you want to get as much information as you can. And you would like to hear from Brian, hear his side of the story, wouldn't you? Of course we would. But what I need you to do is promise me that if at the close of the Commonwealth's evidence, I, as Brian's lawyer, tell him I don't think you should take the stand because I don't think they proved their case without reasonable doubt, you're not going to hold that against Brian. So you adopt that as your fault. And you get them to believe that it's not Brian anything, because they'll crucify you, you're terrible. But you get them to believe that it's not Brian's fault, he's not that say he really wants to tell you that story, but I'm not letting him as his counsel because they haven't proven their case. At least not on the murder, on the one murder. We agree that he's guilty of reckless homicide, and that's what they're kind of guilty of. So the Humble case is a pretty good statement. You'll read it now, if you read the outline. Any doubt as to a probability of bias has to be resolved in the favor of the party facing that bias. So that's a pretty good statement to use also. And that is, if there's any doubt that this person maybe, probably means more than 51%, Judge, then you have to strike them because if that bias is against us, it has to be resolved in our favor. Talk to them, McKay, a little bit. I take my shot. As far as the burden of proof, the Rankin, I think it's a Boy Scout case or whatever the King case that's in there, and the Simpson and Callahan case are all read together. And in civil cases, the defense is not supposed to say that we have the burden of proof, and they stop taking that out of instructions. And as a result of that case, I don't mind burden of proof being put on me as a plaintiff because I think most jurors know that, for one, and two, I want to adopt it as so what I'll do is I'll describe the different burdens of proof during voir dire that are there. And if you look at the Rankin, the Simpson, the Callahan case, all there, you are allowed to do this. You can't define any of them except presumption. You can tell that presumption is 51%. We are just, all our case has to do is be a little bit more believable than theirs on any particular fact and controversy. It sounds so weak to me when you say that. Like, because you know what? Personally, I'm not going to enter a $2 million verdict against this doctor if I'm only 51% certain. I've got to be more than that. So let's talk about the different burdens of proof. And what I need you to do is agree with me that good, bad, or ugly, you'll follow the instructions and you understand the instructions are just presumption. And then on a sheet, I'll put probable cause or reasonable articulable suspicion. That's all an officer needs. Burden of proof for a stop, traffic stop to hold up. It's the lowest recognized in the state of Kentucky. Probable cause is just, hey, is that the person? Do we have the right person identified? And the description of what they did, the allegations, according to the Commonwealth, in the light most favored them, does that even meet the threshold of a felony? That's probable cause. That's to get it to the grand jury. We're not going to bet against it. On the other end, we have beyond reasonable doubt. I'm not allowed to define that, folks, and I'm not sure what that is, but that's what you have to do to send somebody to prison. You know what's in between preponderance and beyond reasonable doubt? Clear and convincing evidence. That's a really high burden of proof because when grandma gets Alzheimer's and we have to take her checkbook or car keys away from her and we get to decide where she's going to live, that's a jury trial, folks, and we have to prove that grandma's that sick before we'll take those rights away from her. That's way up there. We are right here because they've got these great lawyers, because they've got all this money, because they're going to have great experts too. That's what the burden of proof is in civil cases. So when you go back and deliberate and you think our version of events is probably what happened, that's the burden of proof. I'm going to get way up here. I'm going to prove it to you by clear and convincing. But for those of you who are struggling with that, it's just right here. So those cases allow you to define the burden of proof at least to that degree. And I can show you on a chart how I do it if you want. The Hannah case, Judge Stevens and some other judges talks about the court controlling the voir dire, and that litigants have the right to ask questions that could elicit bias. Has anybody ever tried a case in federal court? I know Kent has. I mean, goddamn, you don't get asked anything. You get to submit a few questions sometimes. And how we can have these learned, wonderful opinions like the Hannah case about, and on these other cases, how crucial it is, this fundamental right to have a fair trial. And part of that is the ability to talk to prospective jurors, make sure they're not biased, and then go right down the street to federal court and say, you don't get asked that many questions. It's hard, it's a juxtapose, it's just hard for you to reconcile. But I find that Judge Perry is ex-Air Force. I've tried 3 cases in front of Judge Perry. We went to law school together. We are buddies, but he's a control freak. And I'm not talking bad behind the back. I would tell the same thing. Mitch, you're a control freak. Lighten up. The first time I tried a case in front of him, it was against Don Darby, excellent medical malpractice defense lawyer. And when we got done with voir dire, he said, now you folks have just seen the way voir dire is supposed to be conducted. I'm sorry, it was Don Brown. And that was fine. And I thought that was great, and I thought we both did a pretty good job, and that was great. And it was nice for the judge to say that for the whole panel before the other ones were excused me said. The next case was in front of Don Darby. Now, Don and I have been going around for a long time, and we've traveled together on cases, and I love Don, we're close friends. Not that I love Don Brown, but we were very cordial to each other, okay, and in that trial. And Mitch dresses us down in front of the jury that we are demeaning something of the courtroom by being too friendly to each other. And so, the reason I'm picking on Mitch, and we went at it in chambers, the 3 of us did, because we've all been, not all of us, but those, we've all been, some of us have been dressed down for being the opposite of that, and being unprofessional. And I have certainly early in my career. But what I find is that these judges, that they don't necessarily want to control the courtroom and the jurors and protect them as much as Olu might, but they do want to control the time. And they do have histories of lawyers coming in and asking the same questions that have already been asked during voir dire, stupid questions that aren't going to elicit, questions that are just intended to try to win people over, that's offensive. And so they do want to control the time. So I've tried to get this done in less than an hour. I really shoot for 45 minutes, and I tell the judge that. And boy, I tell you what, if the judge knows you're going to get in and out of voir dire, now if it's a major case and has some science involved in it that I think we really need to get to the bottom of, I might tell the judge that, and they understand that. But I try to let them know that I've got my voir dire going first, and I can get it done in an hour, and then I seem to get more free reins. And so I think their biggest concern is the juror's time, and especially they're right. All right, I'm sorry, Ken.
You're fine.
Last time I looked at the watch, it was 10:10, so it's 5 after now. All right, you guys were great listeners. I'm sorry it was such a monologue. Anybody have questions?
What's the worst thing you've ever seen somebody do during voir dire where you were just like, oh, I can't believe they just tried that or did that?
I've got, when I did one for the KJA a couple years ago, and I don't do that anymore, I've got videotapes. Ken Baker is sitting there talking to the jurors, and we all know Ken, we love him. Hey, Joe. Joe Gutman says hi, by the way.
Hey, Joe. How you doing?
His phone goes off in his jacket, which I guess could happen. During trial, my phone doesn't go in the courtroom, okay? But it does, it's certainly gone off in more mundane days. He took freaking call.
Oh.
And so I played that tape in Paris. So that's the worst thing that ever happened. The worst thing I've ever heard in voir dire that I remember is little Billy Redneck in front of Judge Morris. I had an African-American client, and those of us who do criminal defense, a lot of times will say, is there anything about my client's appearance, and what we really mean is anybody racist. And boy, I said, what this guy, he said, you know what, Judge? I don't think I should sit on this jury because I don't like black people. And we were all, Laura knew, was prosecuting the case, and she went on the feds because she's the best prosecutor. And he said, come on up here, sir. And just with this big smile on his face, he says, man, I can't tell you how much I appreciate you being honest, and that's the court and everything like that. But you know what? I think you're just a racist pig that really doesn't want to sit here. So here's what you're going to do. You're going to go back to the jury pool, and you're going to sit there till 5 o'clock today. And I don't care if all the other jurors are excused for the day. And you're going to come back here every day. You're going to be here at 8:30, and you're going to stay till 5. And I don't care if the rest of the pool is, and he checked on that guy, had to stay there. So that's kind of
Thank you.
Good job. Would you all like to take a break for a couple of minutes?
That'd be great.
And I'll promise I'll pull you out if you're not ready. I may take one more myself.
Yeah. Thank you.
How you doing, Elton? Yeah.
All right, Ken, how you doing?
I'm gonna tell Shirley when you were next.
Uh-oh.
Did you want to use it?
I probably don't.
I think I tried one of the very, very first cases with your commissioners.
Oh, okay.
I'll see if you remember what it was.
Hey, Joe.
Elgin, how you doing?
I'm doing good. How are you?
All right.
How you feeling?
Feeling well?
You were hobbling there for a while. You over that?
Yeah. And I've been out several times. I had gout one time.
Oh,
And
yeah.
this past fall, I was coming down the steps and carrying some boxes and slipped and hit my knee. And I was limping around for 3 weeks with that thing.
Oh my God.
They go to physical therapy and all that.
I don't know who signed me up for getting old, but it wasn't me.
I don't know. Me neither.
Like Westbury, it looks like he's had aging.
I got bad knees. You see me going down the street. I look like Festus and Gunsmoke.
You know, I let my ego get in the way of common sense, which has happened a lot for me.
Yeah.
My youngest son lives in Denver.
Yeah.
A couple of years ago, he talked me back into
Ski.
back on the ski slope.
Yeah, I can't ski.
I took a really bad fall.
Yeah.
Whatever got an initial in that left knee, I tore.
I still try to play tennis. I'm not that, but I like to play. It's just hard on those knees. I'm 60 now, so I'm 60 now, and I've noticed in my 50s, my legs are just.
Ken,
You all are young.
I'm 68.
Are you 60?
Uh-huh.
You don't
Sure
look
enough.
that
You know, I got you both of you beat.
You got to speak, Elton?
You know, 72.
No,
Are
he's
you
kidding.
really? Good for you.
I'm kidding.
We had a 1972 through 76. We were in an apartment house, an old mansion house on Eastview next to the
Yeah.
lakeside.
Yeah.
Block and a half from lakeside. Elgin was one of the tenants. Charlie Mears was one of
Oh,
the tenants.
God.
And I was one of the tenants.
He's 68.
Yeah.
Charlie.
I didn't know that. Elgin was great. You want to do it? You want to die at your desk?
Yeah.
Do you?
I don't want to retire. In fact, Olu was telling about those first three black lawyers that were admitted in '53, and I know 2 of them, Ralph Richards and Charlie Anderson.
I know Charlie. I knew Charlie.
Charlie.
You know Ralph Richards too.
I didn't know Rob.
Yeah. And the other one, I don't know who he is. But I'm surprised Willie Fleming isn't up there. He's pretty.
I would have thought Willie would have been ahead of everything. Willie might have gone to law school later.
I don't know. He still comes over.
I see him at the game. I see him at the U of L games.
He's got a little office over there in the Kentucky Towers. And I'll come in, when our offices were in the Republic Building, which has now been sold to the hotel,
Yeah.
I would see him get out of this Ticket to Ride in the mornings when I was coming in.
Is that right?
He'd kind of bring him down there, and he'd come over and use my secretary's daughter, he'd come over and use her notary. Every once in a while, he'd refer a case to me on a traffic issue. He's still hanging in there.
No, but when, African American lawyers, when I first came out of law school, Willie Fleming, Henry Curtis,
Yeah.
Darrell Owens,
Yeah.
Darrell's got to be up there.
Yeah, Darrell still do. He got some over at family court the other day, and Henry Curtis is still doing.
I saw him. He left town for quite a while.
Yeah. He went out of town for a long time.
Was Charlie the first African American? Charlie Anderson, was he the first? What was it? I wasn't here.
He was the first African American judge, I think.
Yeah,
Jefferson
there
County.
were, the old Jefferson School of Law.
Oh, was he, or was it Ben Show?
Yeah.
He was before Ben Show.
Oh, yeah. I think. Pretty sure Charlie was before Ben.
My dad graduated from U of L in 1950. He practiced out West Kentucky. They didn't have any African Americans, and they had one woman who was Olga Pierce.
Is that right?
Fourth Circuit judge.
I love Olga.
Yeah.
It goes fast, Ken.
Well, I tell you.
These young lawyers, young ladies,
It does.
it goes fast. That's all I would
Goes
kick at anything from this very small, cozy group for the seminar. It goes fast. Take advantage of it when you can.
I'm surprised it was so small today. We've been advertising it, and we've got great speakers. I mean,
Oh, there were 9 people signed up for it.
Yeah.
Not all here, I don't know.
No, none at all.
We did this back, Joe.
Yeah.
Oh, yeah, we did it back in the spring. Is that right, Joe?
I can't hear you, Ken.
I'll have to keep my voice up, I know this.
Now, it's my ears, not your voice.
No, we did this back in the spring, and the seminar.
We did this in May.
NBI.
Yeah.
It was fun.
15 or 20 people.
Yeah, not big. We'll let the other participant come in.
I think we have everybody now.
Do we? Did she make that?
She needed to
Yeah.
step out. So.
Okay. I'll get you all out by lunch, I promise. And it's
You
gonna-
can't, because I gotta take them out
Yeah,
of
you gotta take
town.
them.
Yeah.
You go 12
He
and 1.
takes us to one.
Sorry, I didn't know this. We had a lunch break. As Joe and Elgin know, I'm Kent Westbury. I practice here in town. And if you can't hear my voice, I'm going to get up and try to move around. Just holler at me, raise your hand, say speak up.
I can hear you fine.
Okay. The three of you, introduce yourselves to me.
Michelle Green,
Where do you work, practice?
Anderson, Vaughn, and Allen.
Yeah.
Chris Johnson, Frost Brown Todd.
Oh, very, yeah, okay.
And Kristen Fowler, and Roshi Stevens.
Very good, great. Have you all, the three of you, 5 years or less, is that, or 5 years, what's your level of practice?
I clerked for several years.
Yeah.
I didn't practice under 5.
Okay, all right, am I just guessing about right?
I've been practicing for longer, but I don't have much trial experience.
Yeah, I know, it's harder to get. I'll tell you a story about Elgin. My first job was in the U.S. Attorney's Office. I got out of law school in 1980, and I came to work as an assistant U.S. attorney in 81. I worked there most of the 80s. Elgin, I think I know we tried a case, and I'm thinking it was a postal robbery. We used to do those kinds of cases in the U.S. Attorney's Office. Pretty sure it's in front of you, but you won. I remember that you beat me. And, those are the kind of cases where you cut your teeth. You really learn how to. Judge Johnstone was our judge, I think, and I saw you this morning, but I just wondered if that would have been 81, 82 when we did this.
I was doing it back then.
Yeah.
I don't remember all of them, though, but
I know, it was not a big one, but you did a good job for your client. I'm tasked with speaking with you all about voir dire, the art of asking the right question. Having said that, I agree with the premise. It's really an art, it's not a science. And to Chris's point a few minutes ago, and perhaps Joe and Elgin, having tried a lot of cases, might agree, I don't think there's any really way to prepare for voir dire other than just doing it. Because it's probably the most unscripted part of the entire trial. In terms of trying to get the right question and the right answer, you're trying to build some kind of a relationship with a jury. And, you know, Chris gave some good anecdotal stories and crazy responses that you get. You have to learn to be able to deal with that in a way that doesn't perhaps poison the entire panel, expose a weakness in your case. By all means, never ever argue with a juror, no matter how crazy their answer may be. No good comes from that. We'll talk about that just a little bit more in terms of framing the right question. But building a relationship, building some level of trust as best you can. I liked his example about his father and why his dad was skeptical of pain and suffering. You know, that humanizes it from that standpoint. I think, though, a couple of things. I've tried a fair number of cases in federal court through the years. Voir dire is extremely limited down there. We'll talk a little bit about that as well. But the judges are coming around to some extent, although they still maintain most of the control. But a couple of things at the outset about this art of asking the right question. I've heard it said that it's great if the jury likes your client, but that may not always be the case, particularly among those of us that have tried a few criminal cases. But at a minimum, they gotta like you. If they don't like your client or don't like you, you know, you've got a pretty tough road to hoe. So I think this whole idea of trying to build a relationship, build a bit of a rapport with the jury in a way that helps you find out who you want, who you don't want, and also tries to help you condition the jury subtly as best you can towards your side of the case, whatever they may be. He used Judge Mitch Perry as a good example of why judges like to have control over their time. These men and women on the circuit bench over here are real busy. District court too. To the extent you can estimate how long you think your voir dire will take, that's a good thing. But also, if you can estimate to them just about how long approximately you think you might need, I think they appreciate that as well. Interruptions are common in voir dire selection over in circuit court. They'll bring in some criminal cases in the morning. You may not typically get started until sometimes even closer to noon. Down in federal court, to Chris's point, yes, that's true. When I started practicing, about the time Elch and I tried that case many years ago, the practice among the judges down there, they would ask all of the questions in voir dire. You got to submit something in writing, but it was completely discretionary as to whether or not they asked what you submitted. So that's changed to some extent in federal court. And practicing law long enough, inevitably you're going to end up down there. And you may try a case. You'll have a limited amount of time after the judge, questions the prospective panel on their qualifications, their backgrounds. You get an opportunity to submit questions, and we'll talk about that as well. But I think the same rules kind of apply both in circuit court, district court practice, and in federal court practice. When you finally get a chance to start talking to them, what do you do? How do you get started in a way that will get them to raise their hand, start talking? I think to begin with, it helps to sketch your questions out, those areas that you want to get. But don't be wedded to your outline. I sketch out openings, I sketch out closings. The same with the key concepts you want to do in voir dire. Just don't be wedded to that. I kind of start out by saying something like, ladies and gentlemen, the jury, as Judge Simpson or Judge Stevens said a little while ago, my name is Kent Westbury. This is my client. Let me introduce them to you one more time. Particularly if sometime in my practice I may represent a business or maybe a representative of the company, but whoever's sitting at the table, make sure they know who that person is, what their role is. I'm terrible at taking notes, okay? I may get up and start to walk around a little like Chris did. Always respect the jury's space, okay? A lot of them are preconditioned to what they see on TV with some who's laying it over the table. They won't let you do that. The setup in both circuit court and federal court here in town doesn't lend itself to that anyway. In federal court, you kind of got to hang around the podium. They'll give you a little bit of latitude. Circuit court is far, far more flexible. Look at the local rules. But I try to start out by saying something like, this is an important part of the trial, members of the jury, because it's really the only time that we, the attorneys, I say attorney, not lawyer, just personal, we, the attorneys, get a chance to speak with you directly, you, the members of the respective panel. I've been told, translated, that voir dire, you heard Judge Stevens say the part of the trial at is voir dire. I've been told that translated, that means let the jury speak, or if you want to look at Black's Law Dictionary, according to them, it's Anglo-Norman, Old French form, to speak the truth. Now, I don't get into this French talk, or I don't point out to them that it's Anglo-Norman, or it's Latin, or a combination of any of that. I don't want them to think I'm too highfalutin. But I think, tell them that you have been told that it means, translated, it means to speak the truth or let the jury speak, or something like that. Because again, this is the only time that we're going to get a chance to speak directly with one. That's not entirely true. Some judges will allow prospective jurors to ask questions from the jury box. I've never been a keen advocate on that, and sometimes that gets some interaction with lawyers. But at this stage of the trial, it's significant. And I might even say something like, I may ask a question that's kind of, if not dumb, it's not the best worded question. If I do that, forgive me and tell me that you don't understand exactly what I'm asking. But remember, members of the jury, while a lawyer may occasionally, an attorney occasionally may ask not the best question in the world, there are no right or wrong answers for you all, just truthfulness. And I think that has some applicability both in civil and criminal cases. I'm sure that either Judge Stevens or Chris and Joe may talk about this when he gets to his portion. Let them know we're not trying to invade anyone's privacy. The last thing in the world that we want to do is embarrass anyone. Members of the jury, the last thing that anybody wants to do is needlessly embarrass anyone. So to that extent, if there's a question that you're not comfortable answering to the entire group, that's perfectly understandable. We're sure Judge Stevens wouldn't mind if you came up to the bench and we had a discussion about it out of the presence of the entire crowd. And depending on whatever the judge's practice and preference is, he or she may have already told him that anyway. Again, I think what we're trying to do is build a level of rapport and credibility. I said it a minute ago, don't get too close to the jury box. Over in circuit court, what we have a tendency of doing, we take the chairs, we flip them around, we look directly out into the entire veneer, if you will, and we're sitting behind our chairs. If you use technology, that's great in voir dire. I tend not to use it as much unless perhaps there's a photograph. I don't try as much personal injury cases anymore. I think photographs of catastrophic injuries are probably more relevant to that kind of case. But if you want to use that at the voir dire stage, that's fine. Make sure your technology works. Your generation is much better at that stuff. My college-age kids are much better at it than me. I typically, when I use PowerPoint in an opening or closing, I take somebody with me. I will introduce to the jury in voir dire who they are, even if they don't sit with us during the entire trial, just so there are no surprises. But make sure it works, but don't become entirely wedded to it. Sketch your questions out. Don't be wedded to your notes. And again, I will talk just a little bit more about that. inoculate the jury to bad facts. That's just the legalese way of saying embrace bad facts, take them head on. If I'm defending a trucking company, for example, where there's been a catastrophic injury, you know, and the injury is beyond dispute, embrace it. I think you build a certain level of credibility on the front end from the defense perspective if you acknowledge that the plaintiff has been hurt. When framing your questions in voir dire, be careful not to ask a question that seems to suggest that a disputed fact is not disputed. Does this make sense? That can bite you. You run the risk of an objection from opposing counsel, and I'll give you some thoughts I have on how to make and handle objections in a minute. You could risk the admonition from a judge. And the more likely scenario is that facts don't quite come in the way that you suggested, and if the jury panel that's picked out ultimately remembers it, you lose a little bit of credibility come deliberation time. That's the risk that you have. Who goes first? Who goes second? Joe, Elgin, you all are trying plaintiff's personal injury cases. You'd like going first. That has, depending on who has the burden of proof, of course. I will tell you, I prefer to go second. Because, you know, I'd rather let Joe take the lion's share of all of the questions that might typically be asked. So I'm sitting there listening and trying to, you know, with the help, I usually take a paralegal or another lawyer with me to a trial to help keep notes. We make a flow chart of where people are sitting. I can't do that on my own and listen at the same time. But I prefer second. And this simply means that the first attorney who examines these jurors must delve into some of the more basic and perhaps some of the more boring aspects of the case. But the only point in bringing this up is for those times when you do go second, try to avoid framing questions that are repetitive. This is to the point raised earlier. Be respectful of their time. You know, I had a judge say one time at this point, you know, when you're making an objection at sidebar, Judge Kaufman, a now retired U.S. District Judge, said, when you're making an objection at sidebar, sure, that's part of the trial. You have to do it. But remember, the jurors are back there watching you. And if you all are up here giving them the impression you're not making good use of their time, they tend to remember that. So I'm a pretty easy guy to get along with. I like to get along well with my adversaries, but I have to remember that perhaps too much cutting up, too much needless waste, or give the appearance of wasting of time is not necessarily a good thing. And I think Chris touched on that as well. I like, at the voir dire stage, to ask short, reasonably well-crafted questions, okay? Short, reasonably well-crafted questions. I worry sometimes about the open-ended question. And of course, this always invites follow-up with a prospective juror. But, you know, short, reasonably well-crafted question. How many of you members of the jury have served or had a member of first degree of kin, like a parent, a spouse, a child, brother, sister, in law enforcement in some capacity? So that's kind of short and reasonably well-crafted. Something, the judge may touch on that to some extent in his or her voir dire. Depending on the kind of responses you get, that's something that you may want to follow up on. And that's just a rather simple example. But short, well-crafted. I worry about these open-ended questions because you start to get a flurry of hands, and if it will take an inordinate amount of time not only to keep track on who raised their hand, what their juror number is, but to the extent you want to follow up on something. I mean, again, it's an art. For the life of me, I don't think it's the kind of thing that you can rehearse necessarily very well. You just have to do it. You have to take your lumps and learn from that experience. Short, reasonably well-crafted questions, in my opinion, should avoid legalese. You know, don't talk like a lawyer. You know, don't say the testimony of my client would be corroborated by the, you know, just say it'll be backed up. This is an undisputed fact. To that point, I mentioned a moment ago, be careful about creating the impression that disputed facts are undisputed when in fact they really are. One tactic I think most judges in circuit or state court in cases that lend themselves will agree to, if you and your adversary, opposing counsel, can't agree upon a rather short factual stipulation as to what the case is about, have the judge read that at the beginning, and then your questions can kind of flow from that. It's been my practice, good lawyers don't shy away from it. May not agree, may not ever agree, but if there's something that the judge can read, then you kind of craft your questions from that after as well. Asking the right question, you know, I think I mentioned adapt a style that you're comfortable with. I'm not particularly good at flamboyance or bombast. Some lawyers are very good at it. It depends, of course, on the case. But, you know, I've come to believe, having done this about 35 years, that jurors can sense insincerity. If you're asking the question in such a way that it's not really susceptible or it's not really suited for your personal style, it perhaps may come across as insincere. I think you need to kind of, you know, ask yourself, you know, what's the best way for me to frame a question? I think humility goes a long way. I think jurors are a little naturally suspicious of who we are and what we do for a variety of reasons. Perhaps it's what they have seen and learned on television. But to the extent that you can project a good command of your case, that you're confident in your case, through the way that you're asking the questions and framing the questions, but also do it in the most humble way possible. Lawyers are inherently not humble people at times, but I think some of the very best lawyers I've ever seen do that way. That's kind of a style that I've tried as best I can to adapt to my own personal use. The question that you ask, I suggest you craft it in a conversational tone. You want to get a conversation going. To Chris's point earlier, you want to get them to raise their hand, but do it in such a way that, you know, you're getting the jurors, you're getting to know the jurors, make them feel comfortable speaking with you in such a way that they will open up. Personality types to watch for when you're crafting the question. And, you know, I'm probably touching into some of the discussion that others have had this morning and perhaps in the afternoon. I kind of like those that are willing to engage. Now, you know, Chris used the racist example earlier. I find that to be more the exception rather than the rule. You do find, I think, in personal injury cases at the outset, there are prospective jurors that are a little skeptical about this concept of pain and suffering. I found in the criminal context, I have found jurors that are a little skeptical about this concept of reasonable doubt. We'll talk about that a little bit. But for the most part, you know, in the years I've been trying cases, I'd estimate about 40 to 50 trials to a jury in about 35-ish years of experience. I haven't had any really outrageous comments from jurors, but I do get a lot of folks out of the perspective panel, like the girl with tats and the earring in Oakland County, you just sit there like bumps on them. So what do you do with it? You like those that are willing to engage for a variety of reasons. So craft your questions in such a way that gets them to participate in the process. But what do you do about those that for the life of you, they sit there, they seem disinterested? I find a lot of younger, I'm just talking to a group of lawyers here, I find younger jurors, depending perhaps on their level of education, to be quite frank, just sit there and absolutely refuse to engage. What do you do with that? Are they followers rather than leaders, perhaps? Do you necessarily want a lot of leaders on your jury? It just depends. Those who are disinterested, especially those that are contentious and confrontational, those are hard to reach with your arguments. Try to avoid the know-it, is what I'm saying. But the trick is to craft the question in such a way that, you've given that disinterested juror every opportunity in the world to participate, and they still refuse to do it. I don't trust them. I want somebody back there that would be an advocate for hopefully doing the right thing, seeing your client's side of the case. The flip side is craft your question in such a way that you will expose the man or woman on the prospective jury that perhaps you've seen them. They raise their hand on about every question. They seem a little anxious. If you can discover their leanings on some of the relevant issues, you might find out that they might just advocate for a position that would be disadvantageous to your case. Here's an example. Some folks seem set on depriving a plaintiff of money damages simply because of their prejudice or misunderstanding of the judicial system, or extremely believe that damages should never be awarded. I had one juror one time in a prospective criminal case, say something like that. The judge would typically say an indictment is not evidence of anything, it's just a mechanism of getting a case to where we're at today. One juror raised his hand and said, well, where there's smoke, there's fire. It was in federal court, and the judge, as federal judges are prone to do, they were very quick to admonish that and say that that's unacceptable. That fellow got struck for cause, of course. I didn't even have to exercise one of my strength. And the advantage to having it done in that situation is I didn't have to take the point as a defense attorney in trying to rehabilitate that character, smoke and fire character. The judge did it for me. That gave a certain level of credibility. I'm doing something right now that I've got some do's and don'ts that I like to speak to about phrasing the right question. But my question to the three of you all, do you have anything of me, or Joe, that we could, do you have any questions? The advantage to a group this size is we can make this truly conversation. Anything. Any thought on your mind? You got to simplify it. You have to. Particularly, you work at Brown Todd, you all are going to litigate a lot of complex business cases. They don't always get to trial. But regardless of your case, you have to find a way at voir dire to let the jury know what it's about, but in a way that they perhaps can comprehend it. I've been told studies have indicated, perhaps it's out of date, I think from the ADA, the average juror has the equivalent of roughly an 8th or 9th grade education. Maybe it's a little higher now, but I doubt you're ever going to have a jury that has made up of 12 men and women with graduate degrees or substantial business experience. How you craft your voir dire in such a way that lets the jury know what the factual basis of the case. really hold it down. That's an art, yeah, go ahead.
I guess I do have a question. So along those lines, and along the lines of what you've been talking about, some of the cases that we do handle that do sometimes go to trial are representing insurance companies.
Yeah.
Not insureds, but bad faith cases,
Sure.
UIM cases where, at least among defense attorneys, there is a perception that jurors are inherently biased against
Yeah.
insurance companies or think that they have deep pockets or want to shortchange, especially if you're adverse to an insured rather than a
Yeah.
third party. So, in my mind, and I've thought a little bit about this, voir dire would be an opportunity to, first of all, try to uncover some of those biases and determine who to strike, either for cause or use peremptories on. But also, you could use it as an opportunity to, explain sort of your theme and your theory and kind of try to personalize your client. Because in my experience, the people that work for insurance companies are great, regardless of whether you like them or whether you don't. I've heard you give some examples about, from a plaintiff's perspective, how to, and others have given examples about how to deal with the burden of proof or how to, deal with different issues that come up regarding, awarding pain and suffering or others. On the flip side of that, how would you approach it if you were a defense attorney representing an insurance company?
Yeah, I do.
That was a very long question.
No, that's a good one. That segues into something, ordinarily it's taboo to mention insurance. Now, the exception, of course, is when an insurance company is a first party, a direct party, a defendant to the case. Could be a plaintiff, I guess, in certain circumstances.
And that's what makes these cases different, because of course collateral source would keep all evidence of insurance out of normal cases, but those aren't the ones that we get. So
it's probably most akin to when you're defending a company or a corporation, big or small. Okay, big or small. In all likelihood, if it's an Aetna or just picking a large insurance company, thousands of millions. What if it's a mom and pop company involved in a breach of contract case? Who makes up that company? Start to read on some examples. Do you know, for example, that the Aetna insurance company is made up of these kinds of people? Okay. I'm trying to think in the business cases that I've handled. I'm trying to think of some of the best examples I've seen to humanize who they are. It's easier in a small company because you can say there are 10 employees. Okay, and here they are. Here a brief description of their job responsibilities. Perhaps you could find a way within the corporate structure of your insurance client to do the same thing. It's not a nameless. A company is, at the end of the day, is made up of people. Not too terribly different from any of us. It's not nameless. It's not faceless. They have families. They have the same responsibilities as any other citizen in this country. That's who makes up a company. That's who it is. It's not this monolithic, impersonal sort of thing. And ask them, do you understand that? And try to frame a question that says, you'll be asked to render a verdict at the conclusion of the trial. We hope you render in favor of our defendant, but try to think of the proper way to phrase it. This impacts the people that make up the company as well. Do you understand that? Do any of you have any problems with that? This is back to the point I mentioned a moment ago about maybe having a stipulation with the opposing counsel that the judge would read at the beginning of the trial. Try to have something in that stipulation that's consistent with the point that you're trying to make. But you got it, however you go about doing it, whether it's a large company, or in particular a big insurance company, humanize them. It's not, these are people that make this business up at the end of the day, and there are consequences, to that. You got to be a little careful with the consequences example. I could see whether a court might find that prejudicial. But humanization, that's the trick, I think, on that. Anything else, guys?
I was curious, you alluded earlier to making objections or responding to objections that might come up during this process.
I don't like to make objections during voir dire if I can do it. You know, Joe and I were trying cases, great experienced lawyer, we're friends. I just don't like to do it. I think there's a perception that is, so here's a couple of tricks I've seen that seem to have worked. Depending on your judge, okay, ask at your final pretrial conference, either civil or criminal, if judge, this is particularly pertinent, I think, in circuit court practice, state court practice. If I have an objection to my opposing counsel's questions, can we just have an agreement that all of those will be handled up at the bench without the necessity of me doing much more than maybe signaling, you know, a request to come up? I've never had a judge turn me down. You know, you don't want to abuse it. Judges in civil cases, I'll just tell you, have wide latitude on objections. It's going to, you know, it's important to preserve your objections, Chris pointed out earlier, but the practical side of that, particularly in a civil case, it's going to take a pretty substantial abuse of discretion to get a reversal. But having said that, you need to make your objection. I just don't like to do it in voir dire. So does that make sense? See if the court will let you just have an agreement on the front end. We'll handle all voir dire objections up at the bench. You know, maybe they won't do it. It says, no, Westbury, you're going to have to object every time. If they do, they do. But exercise your objections in voir dire if you have to do it in front of the entire panel judiciously. Criminal case is a little different animal. You have an entirely different set of rights that you're trying to look out for. Does that make sense? That's my personal preference. Others may disagree. They don't mind objecting in front of the jury. Trying to think. No plan of attack survives contact with the enemy is the old saying. And in this context, that simply means you can sketch out, craft out all voir dire questions that you think you can. You can do it in the way, perhaps, that's been suggested this morning. And all of that goes totally out the window when you start to interact with the prospective juror. Don't cut a juror off, regardless of how bombastic their question is. If they say something that is particularly objectionable, like I don't believe in the concept of reasonable doubt, no plaintiff's ever been hurt, you will, I don't get that a lot, but occasionally you will. Perhaps you have a standing agreement with the judge that you can take that up at sidebar afterward. Never argue, I mentioned that earlier, forgive me for being repetitive, but I think try to, you just have to get in the frame of mind to be able to bob and weave with them, with the back and forth. I find that most jurors, the ones that you can get to engage, are pretty respectful of the process. They don't have a lot of bombast. Again, it's the one that sits like a bump on a wall that you worry about. And having said that, you're going to get them on your pen. It's going to happen. You have a limited amount of strikes to exercise, there's no perfect way to avoid doing that. The administrative office of the courts compiles county by county sort of a master list of potential jurors. They've taken, as I understand, I looked at the statute just to refresh my memory. They come from tax returns, tax rolls, registered voters, and licensed drivers. It's essentially the same thing in a particular district, the Western District of Kentucky. It's just that comprises multiple In circuit court, you really don't have much time, you know, to look at that, to look at the information. In some cases, the judges will allow you to submit a questionnaire. It's part of voir dire. You may not always have the resources to do that. It's going to depend on the kind of case you got. I find the judges down in the Western District, particularly in criminal cases that I try, are pretty lenient about that, assuming that you don't misuse their time. In federal court, you can get the prospective jury list and the basic questions that they respond to approximately a week before the trial. That's better than nothing. Okay? It kind of depends on the judge. You know, they have it's discretionary, but for the most part, that's something that you take up at the last pretrial conference. So that will help you some when you try cases down there. At least they'll have questions about where they work, their age. They're supposed to disclose whether they've ever been convicted of a felony or not. Most of them, in my experience, answer that truthfully. The trick you got to find out, what if they've had a close family member that have been convicted of a crime? As a prosecutor, you wouldn't necessarily want that, but those are the kinds of questions that you need to answer as well. We're right up here to about the break before Joe starts. I got just a couple of things maybe to conclude. When to ask follow-up questions to chambers. And I could read this part a lot better, I think, than I could try to craft it. If during voir dire it appears that one of the jurors has expressed a clear bias, prejudice, but some follow-up is needed to determine if there may be grounds for a challenge for cause. And to avoid an answer that might poison the entire panel, you've heard in open court. You know, again, this is what I was just suggesting a minute ago. Ask the court for a bench conference. And perhaps the best way to handle that is to do that at the final pretrial. Judge, you know, how would you like to handle these kinds of questions? We don't anticipate they're going to happen. We're certainly not going to intentionally craft a question that's designed to poison the entire panel. But in the event that it happens, what's your practice? How do you like to handle it? You know, could we have an agreement that at some point during the trial, either right after the question is asked and answered, or at some other point, we can talk about this at the bench without me having to raise my hand. Finally, these are the do-nots that I would suggest. Don't stand behind the podium when you're doing your voir dire. Again, in federal court, you're a little more constrained, okay? But they'll let you move around the lectern. Don't read questions. But having said that, I do strongly think it's a good idea to have your basic questions crafted out. Don't be boring. Try not to do it. Be respectful of the time, but don't be flippant with them. Don't try to inject humor when it's inappropriate. Jurors like a little levity. They like a little lightness. Never argue. And of course, don't ask potentially embarrassing questions of jurors. And sometimes that's easier to say as a concept than actually not doing it in practice. And that you're just going to have to tailor that to your particular case. Finally, and I've said it several times again, there's no practice for voir dire other than really doing it. Go do it. Find a way to take your lumps. I find, you know, all lawyers have ego. We don't like to be embarrassed. You know, Kate, I've asked questions before in cross-examination of a witness, and I think, oh shit, you know, why did I do that? I find that the most times that I've been a little embarrassed is during voir dire, because I didn't do a very good job when I was interacting with a prospective juror. Maybe I cut them off. Maybe I asked a goofy question and the juror called me on it. Take your lumps and go on. Put your poker face on. Show a little humility. I'm sorry. Didn't mean to do that. Let me ask another question a little bit better way. anything to project that kind of humility. And again, having said it, I was thinking this part of the trial, just actually doing it, any chance you get is probably the best way. That's all that I have. So if anybody has any questions, otherwise I'll turn it over to Joe Susan.
Thanks, Ken.
All right, thank you.
Thank you.
Elgin, if you remember what that trial was.
I'll call you.
It was, yeah, you call it, it's about 34 years ago. It's my best recollection.
I did have the only time I ever had a question about the Colorado appeal was Judge Johnson trial case, and after the whole thing was over with, and he already discharged a juror. The juror called Johnstone and said, "I think I remember that I've tried to sell some windows or something to the defendant." And he called him back in, and the court. He called before I appealed it. He called the juror back in. We had a hearing on it. And he explained what he thought he did know the guy, but it didn't affect his conviction, you know. And I appealed it, and the court said it was harmless error.
News reports, if you all have a case that may have jumped into the papers, as you practice longer, that's going to occasionally happen. We had a situation in Frankfurt where we actually, there were many grounds for reversal. It was a Clay County Board for one case with Judge Cletus Miracle. I had the superintendent of the school. It's about 4 or 5 years ago. We got it reversed, but the jurors were admonished from the beginning, do not read news reports, okay? We got some information after the deliberations and after the verdict had been returned that what was discussed back during the deliberations, news reports of the trial, it was covered up. So we made a motion, you know, there's a mechanism to have a hearing. I won't bore you with that. But this, I'm told, this is really more a problem if you try cases in the small counties, the rural counties. The local press pick up an automobile injury, have a little description, maybe months, a year or more before the actual trial. So be on the lookout for, make sure you preserve your objection to those kinds of things, and don't hesitate to make your record. Thank you.
Thanks, Ken.
Thank you so much.
Thanks.
Does anybody need a few minutes before?
You have such a small group.
Yeah, I'm okay to keep going. And likewise,
You take a break when you need it.
I have a biography of you, but we're such a small group, and we've been calling you Joe all day, so I don't think I'm going to.
Let me get, I know Elgin very well. Your first name?
Michelle.
Michelle? Well, we have such a small group, we're going to make it a lot cozy.
Chris.
Chris?
I'm Kristen.
Kristen, okay. Okay, the judge he just talked about, I'm going to give you a war story. My name is Joe Souza. I've been practicing law since 1974. Elgin and I were in the same apartment, small six-plex over in the Highlands for 1972. How many of you have tried, I know Elgin has tried, how many of you actually been through a jury trial? Where you've been, okay, how many of you been more than 5? Okay, that is the indictment of your generation. It's one of the things I feel, other than lawyer advertising, it's the worst thing that happens to trial lawyers. You guys don't get enough experience. It's unfortunate. My next trial will be my 94th jury trial. Many of those were one day. Many of those were jury trials when I was a prosecutor, paternity cases, arson cases. The last 50 or 60 have been pretty complex, week or 2 week or 3 week or 5 week jury trials. So my lament as a lawyer in 68 and he's 72 is that you guys, Kristen and Michelle, are not going to have multiple opportunities to make all the mistakes I made and learn from them. So the judge he was talking about, his name's Cletus Miracle in Clay County, Manchester, Kentucky. I've never been treated worse as a lawyer, ever. In any state, in any jurisdiction I've ever been in, I was treated by Cletus Miracle. I'll make it a long story short, a malpractice case, we represent Maddie Smith. We sued a guy named Dr. Bill Becknell, referred to in Manchester as Dr. Bill, Been there for about 50 years. Dr. Bill had a patient named Maddie Smith who hit her head on a radiator, went to the hospital, got woozy. He diagnosed her with congestive heart failure. A first-year biology student could not have diagnosed her with congestive heart failure. There wasn't one clinical sign of that. She had a head injury. He treats her as congestive heart failure. She starts getting addled, losing memory, cognitive deficit. He gives her some diuretics. God forbid the diuretics worked. They shrunk the swelling on the brain, which was happening to Maddie. She had a subdural hematoma. The blood gets bigger and bigger and bigger, compresses the brain. The brain of all our organs dies first. So we are in front of a malpractice case, and there's a Joe Clark, God rest his soul, was the defense lawyer. And Joe says, I'm filing a motion for summary judgment. I said, Joe, whatever you file, I've got a doctor that's going to file an affidavit counter. I'm going to file that anyway. Files a motion. Dr. Bill Becknell did nothing wrong. I file a motion with an attached affidavit. Dr. Bill Becknell did some bad stuff. It's a dog fall, right? I mean, it's elementary. Dr. Cletus Miracle hit the bench. You're Joe Clark. Kristen, you're Joe Souza. Joe, what's this all about? The judge, it's a motion to dismiss. Dr. Bill McNeil didn't do anything wrong. You'll see an affidavit in the file. Counsel, what do you have to say about this? It's the judge. There's a packed courtroom. I mean, there's one, maybe they had one motion a month, one motion hour a month. There's 80 or 90 people in there, all local lawyers, great guys, all friendly. People wore holsters, guns, walking around the streets of Manchester. God is my witness. Sheriff told me we lead the country in unsolved homicides. Clay County led the country in 1978, or no, 83, with unsolved homicides, because they don't tell anything. If somebody gets killed, they'll figure it out. They'll work it out themselves. So I'm kind of dark-looking Italian lawyer in Clay County, Kentucky, stuck out like a sore thumb. Dr. Bill didn't do any harm. What do you got to say about it, counsel? As that is pretty elementary. The case of Weinstein versus Sahlberg says, when you have countervailing affidavits, the court cannot give greater weight to one affidavit over another, unless the area of expertise would be inappropriate, like a layman versus a doctor. Anything else? No, sir. Motion signed. Dead silence in the court. Every lawyer there knew this was not appropriate conduct, despite the fact that I'm a non-resident lawyer. So I'm walking out. I said, Judge, before I leave, I said, just make sure I'm clear about this. There's a case called Weinstein versus Sahlberg that says countervailing affidavits have to be given equal weight and no court. That's right, counsel. So I walk out, 3 or 4 of the lawyers say, really sorry about that. About 6 or 8 months later, one sentence, Court of Appeals, case remanded, motion, appeal sustained, plaintiff's appeal sustained, motion remanded to the trial court. End up selling the case. Well, the war story isn't voir dire. It has nothing to do with voir dire. It's what about how judges will treat you. Okay? So if Elgin's tried 50 or more,
More than that.
100
This
jury trials, Elgin probably leads the state.
Not circuit court, district.
No, these are well, about 5 of those were district court. No, more than that, because I was doing all the DUI stuff back then. The opportunity doesn't exist for you guys. So, what can we learn from today for the guy that's in the second half of the 4th quarter, talking to very nice, three nice young lawyers and a nice older lawyer, how to do this? Voir dire is pretty simple. All right? The jury's first impression of you is what they're going to see and hear from you. Voir dire. I disagree with Kent. Of course, Kent's been doing defense work for so long, he likes to be second. But I've had voir dires where I've spoke for an hour and 20 minutes. The defense lawyer gets up there for 10 or 15 minutes because I've covered all the issues. Right? So he doesn't have much to say, and it's not that he doesn't have much to say. They're far better lawyers than I would be. But he never has an opportunity, and you as the defense lawyer, Chris, probably more likely than not, never get a real good opportunity to establish some kind of rapport with the juror base. Okay, so
But it's the same way when you're doing criminal defense work.
Sure.
You're defendant, you get to go second.
Prosecutor lays out his case, horrible injuries, assault, battery, or murder.
I always my theory was, I don't even care if I didn't have that much to say. I wasn't gonna let them get, 45 minutes in front of the jury smoozing them, and I only stood up there for 10 minutes. So I always tried to find something that wasn't redundant, but I still got up there and tried to get them to identify me, because they've been listening to this.
I think that's a good technique. I'm going to give you a trick that I stole off another lawyer. Most of what I have here is what I've stolen. I mean, there's probably only maybe 2% of this is individual, private, independent thought processes. So imitation is the highest form of flattery, and I've stolen the stuff that worked against me and the stuff that helped make me a better lawyer, I hope. But one of the things you can do, and I'm going to bypass this for a second, you need a theme. All right? You're not going to try 100 cases. The likelihood of you trying 25 or 30 cases is reasonable. He's tried 100, I've tried 90. We've been practicing for 40 years or more. That's 2.5 cases a year. And many of those were one day, legal pad, defense lawyer, chiropractic injury, rear end collision. I did a lot of defense work when I first came out of law school. One day, you had a voir dire, you put on he was the plaintiff's lawyer, he put on the plaintiff, I would call the defendant, he put on a doctor by deposition. Nobody could afford to bring a doctor in for a $5,000 case. We put our doctor on by deposition, the chiropractic notes, and you were at jury verdict at 4 or 5 o'clock in the afternoon. So those days are gone. It's hard to get to a jury before 1 or 2 o'clock in the afternoon on a regular jury day, and then voir dire takes a long time. It's gotten so expensive, it's very difficult to try those cases from the plaintiff's perspective. It's helpful for the defense because that's where the proving ground is, in the trial room. So you need a thing. So if you're only going to try 20 or 25 cases, maybe you're lucky and try 50, or unlucky and try 50. There's nothing better than winning a case. There's nothing worse than losing. You're sick about it for a long time. So how do you build that? I would recommend, if you haven't already done it, I mean, the trial binder system has been in effect for 40 years or so. One of the first things you do, whether you're the defense or whether you're the plaintiff, where would you be from? Mostly defense? Plaintiff? Okay, we've got a split jury. All right. So that trial binder, the first thing I would do as a plaintiff and as a defendant is get what you think are going to be the jury instructions that are going to be used in your case. Because the words and the phrases that are in those jury instructions will be helpful to formulate your discovery when you're asking questions. If it's unreasonable use of discharge of a firearm, or it's knew or should have known of a hidden defect on the premises. Use that language, and that helps you frame kind of what the theme is. In the simple automobile case, in the simple slip and fall case, I can't give you a theme. I'm not that brilliant. But there's something happened in your case that's going to be different than all the other cases. I didn't see it. I was 10 feet away. Were you watching where you were going? It used to be, before comparative negligence, contributory negligence. And I used to go up to the screen when I was doing defense work, and I put this big board up there. And I said, if this is all the negligence in the world, and I just buy a little circle like that. I said, and the plaintiff was negligent to that degree, he doesn't get a verdict. If his negligence is that much, it's contributory negligence, and we won a lot of cases that way. I remember friends of mine won 95 stop and shop cases, slip and falls in a row. 95. I have defense lawyers in malpractice that have won 30, 40, 50 malpractice cases in a row. Not in their life, in a row. I mean, their statistics are, you don't do malpractice, do you? Yes. You do. But you know how complicated they are. I've tried about 20, I've lost about 12. They are difficult cases.
But only the bad ones get tried.
I don't know about that, Elgin. Sometimes it's just on value. But you're right, for the most part, the ones that are weak cases get tried, the ones that are strong get settled. That's true. So we talked about instructions, trial themes. How do you develop a trial theme? There's a couple of people much smarter than I that have just given this an acronym for the word success. Simple, unexpected, concrete, easy, credible, emotional, and story. Simple, unexpected, concrete, easy, credible. That's what you're going to try to develop for a theme. And the simpler the theme, the better off you're going to be. So these are quotes from, there's the reason I handed out my card, not to get business. The reason I handed out my card was there's a large segment of printed materials that I've produced in another seminar that were not attached to your stuff. If you want them, email me, call me, I'll send a copy over, and it'd be very helpful. I'm skipping through a lot of this. This was a 2-hour seminar that I've condensed into one. Theme doesn't work until it grabs your heart and gut. A tagline, a short phrase or two that helps explain a movie. That's what a tagline is. That's what you need to help explain your case. I mean, if he's trying a murder case, there's no body, there's no fingerprints on the weapon, that's his theme. You know, what's O.J. Simpson's line? The glove doesn't fit, you must have quit. Yeah, okay. So I still remember that. As bad as that trial was, horrible verdict. As bad as that case was, they won, the defense won that case. So what I could tell you and predict about juries in my past and in my future is that you can't predict anything about them. I've won cases I should not have won. I've lost cases I didn't think I should ever lose. I've lost cases to bad lawyers. I've won cases against good lawyers. So a jury is going to be who you're speaking. That's your litmus test, right? So we're going to get our case, explain the trial story. There's some part of the story in every case that is helpful to the defense or it's helpful to the plaintiff. When I'm in voir dire, you cannot gloss over the pimples on your case. You need to bring them out. If you've got a doctor that isn't particularly nice or isn't come across particularly well, and it's going to be a problem, you need to say that. Dr. Johnson is not the most personable man. I've been his lawyer for 3 years, and I got to tell you, he's dutiful, and he's academic, and he's smart, but he doesn't come across warm and fuzzy. Don't hold that against him. You know, so whatever it is. Mrs. Johnson is here before you to seek damages for her injury. Don't let me get me wrong. Miss Johnson was involved in a car wreck in 1980 and in 1984, the similar areas of her body. But you're going to find out that put her in a fragile condition. She was more likely to be hurt. And the fact that we don't have any MRIs that show the difference, you can certainly hear from her family and her friends what effect it's had on her life. So whatever you have, is, Charlie Leibson, God rest his soul, was a great lawyer. He was a mean trial judge, and he was a great appellate judge. But he said, that's workshop your problem in whatever. Get it out. Don't let the defense get up and say, well, you didn't hear about the fact that Ms. Johnson had 93 accidents or slip and fell at Walmart and Kmart 3 or 4 times to the same part of the body. And the chiropractor she'd gone to is the same chiropractor so get those things out. Tagline. You can still see Jack Nicholson, right? I want the truth. You can't handle the truth. You remember that, and I think everybody remembers that. One of his finer moments, and he's had plenty of them. So you can't handle the truth. Maybe the defense can't handle the truth. You know, one of the things defense lawyers and plaintiffs lawyers need to be aware of is juries across the country are, for the most part, disrespectful of people's inability to accept responsibility. So if your guy slips, you need to say some of this is his fault. Right? And if you're representing Kroger or slip and fall with a doctor, some of this you can believe might be caused, but by the same token, he didn't do anything. He didn't come back to the hospital. He didn't come back. So, we'll go through it. All right, here's a quiz. There's only 4 of you, so we can talk. Anybody remember what that movie is? Uncle Fess or whatever it is saying, he tells the Spider-Man, great power comes great responsibility. So, but it's a line I remember, and his whole life is $1 million to 1 shot. Any guesses?
Rocky.
Rocky.
I cheated.
You looked at us, you can't do that. Damn lawyers, it's too smart for me.
I turned it before I realized.
All right, that's okay. That's all right. We're going to deal with it. He's having the worst day of his life over.
It's Groundhog Day.
Groundhog Day. Okay, one of my favorite movies. But you got to like movies to remember this stuff, and they need to like you or your client. And if they don't, that's a problem. You can't spend 10, 15, 20 an hour with a jury that don't like us to begin with, right? And you can't convince them that you're good and smart and trustworthy. You have to earn it. And one of the phrases is lawyers who try less than 5 cases, you need to tell them, I don't expect you to give me your respect and trust. All I ask you to do is give me an opportunity to earn it. It's a phrase, it's a trick. It's not a trick, it's a good, solid question. It's helpful. These are just things that I've seen other lawyers do it. I like it. Rule of threes. Okay? It's whether you're doing, I just learned this, in architecture or in interior design, if they want to come in and do this room. For example, you have the green marble, right? Edges. There's no other green marble edges or green in this room. So an interior designer said, we need to do something else. We need to make one of this pillar green, or we need to have an awning or something. So it's the rule of threes. It's helpful for us. Things that come in threes are inherently fun and more satisfying with them. It's not my words, psychologists. You need to remember the points best when you give it in groups of 3. Rock, paper, scissors. 1, 2, 3 strikes, you're out. 3 blind ones. Okay? That ring, it resonates with the jury. You're all laughing, but you're laughing because you remember those phrases. And it resonates with you. So when you have only an opportunity to fine-tune 1 trial a year for the next 30 years, or 1.5 trials a year, or 1 every 2 years, take the time to try to find something in there. You can't make a slip and fall on a banana peel different. You got to find something in there. And if there's not something in there, this doesn't work for you, don't use it. I don't remember these movies. I don't know why I gave you so many movies, but it's the last 2 taglines from the account job sound better. Get in, get out, get even. That's something they'll hear in voir dire. There's something they're going to hear somewhere during your proof. They're going to hear it in closing argument. Okay. Somewhere, somehow, something. Create simplicity aids recall, because what you're hoping is that that theme you try to develop in voir dire, someone's going to hear in the jury room when they elect the foreman. Yeah, I know, get in, get out, get even, or something towards that. Keep the theme simple. The more complicated thing, the faster you lose the jurors. There's evidence, statistical juror evidence, that people can listen for about 7 to 17 minutes, then you lose them. So you can't have a theme that is, there was a banana peel here for a long period of time, and the defendant knew of it and should have known of it, and that's why they fell. Okay? Didn't say it. I don't know what your theme would be for that, but you would say, distract me and let me fall. Sales, every corner of there's the stuff that you can't find on the shelves right there. If you want Mountain Dew or Coca-Cola, they're there. But they're not next to where all the other sodas are. Or it's paper towel, something that's spontaneous. Oh yeah, I remember I need that, and they throw it in there. So keep it not in your written material. I'm not going to spend a lot of time on this. Y'all, when you get this old, you've had sad cases, you've had good cases. I'm not even going to tell you about it too much. Those second floor windows. I sent my sister to the UK. I sent my daughter to the UK. Those are the Kerwin's Landing. Any of you go to the UK? Well, those are the Kerwin's Landing towers. They were built in the 60s. And they were the 2 largest dormitories in the state for many, many, many years. They still may be. They're small little dormitory rooms. You must have known them.
My brother.
Those windows, when did your brother go to school there?
Oh, he's actually there now, so.
Okay, well, your brother's safer now than he was then. There's a bar across these windows. These are little alcove windows like this. And now there are bars, aluminum extruded bars, protecting it. Because 15 years ago, 2 young boys that were the brother and the best friend of a student, one student, one brother, fell from those second floor windows to the death. And when the evidence came in, UK had 650, thereabout, windows broken in every one of these doors. And never did anything to make them safer. So a long word, a very sad, very 19 to 20-year-old boys. If you can digest every one of your cases to 10 words, whatever it is, malpractice, slip and fall, automobile, civil litigation, criminal, if you can reduce it to 10 words, that'll be helpful to you. So I had a lot of words, digesting it. So just 2 boys fell, died, danger known, UK did nothing. It's 9 minutes. If you can get that story across, which when we tried that case, the UK did nothing, knew of the danger and did nothing. So you would think that was, before I even thought about themes, that's what we tried to digest. So, pop quiz. This is good for you. Did you look ahead?
I have not yet.
All right. Jeff, I want you to get a pen and get your pen out. On a sheet of paper, I want you to rate him. When you hear these words, I want you to rate him. Wait for Michelle. Need a pen?
Oh, I got one. Thank you.
All right, we're going to rate him on a scale of 1 to 10. I'll tell you what the 1 to 10 is in a minute. Envious, stubborn, critical, impulsive, industrious, and intelligent. I want to rate you 1 to 10 based on 0 is bad and 10 you wanted to marry your son or daughter. Let me go back over. Envious, stubborn, critical, impulsive, industrious, and intelligent. Don't think about it. Just write the number down if it first comes into your head. Here's 2 themes on the same facts from the prosecutor and from the defense. Kelton does mostly defense. I was not good at defense. Everybody got convicted when I tried it. But I was a pretty good prosecutor. Strong-willed young man who refused to take no for an answer and rapes a young woman. That's what I'm saying. Elgin, remorse-filled young woman who regrets a one-night stand and now gets raped. Same facts. Completely different story. So the evidence is, and we're going to skip around a little bit, jurors, people like to hear stories. It emits, and they've done brain studies of it, it emits oxytocin. And it actually admits it. When they listen to a story, it emits a pleasant or unpleasant enzyme. Maybe it's a chemical. So it helps them want to bond to your story. And the evidence is, once they bond to your story, they'll forget about all the bad evidence. If they bond to your story, they will find the things in your malpractice case that they like. Despite the fact that you've got an expert that says, cardiovascular disease was not a proper differential diagnosis. Even though they treated him for that and forgot about the fact that he had fallen on his head and had a subdural hematoma. So, there's a strong-willed young man who would take no for an answer. That 12, 24 jurors, 2 of them are going to bond to one side of that story. It's your job to make them like your story better. You have to tell the better story. But you can't alter the facts. If the jury finds that you've altered the facts to make your case sound better, you lose all your credibility. And it won't be helpful to you. By one story or the other. Repetition. So in voir dire, you want to get something in voir dire that, remorse-filled young woman, it's regrettably, I understand they're 22 years old, you're turning from a young boy to a young man, or you're turning from a young woman to a mature woman. There's going to be issues, and one of the issues is going to be sexual relations and how you deal with that, and there's going to be difficulty for all of us. So, repetition. I have a dream. I don't need to tell you where that phrase comes from, right? Well, and I read it a couple more times in the last 6 months. It's 6-page speech. I put it from a repetition, or that's hyphen came from. For example, the word "we" was used 30 times in that speech. Freedom was used 20 times, and I have a dream only 6 or 7. But what we remember about the speech, that's the thing that people remember, right? Don't ask what you can do for your country. Don't ask what your country can do for you, that's what you can do for your country. All right? John F. Kennedy, I was 21 years old. No, younger than that. I was 16 years old. So those are the things you are trying to get to, and I can't tell you that you're going to be able to find those "you can't handle the truth" taglines in every case. But search for it, and if it isn't one that jumps out at you, then get one that works. All right, there's a second pop quiz. We got another guy named Clinton. He's intelligent, industrious, impulsive, critical, stubborn, and ambiguous. Give me the number. 0, you don't like him. 10, you want him to marry your son or daughter. All right, Elgin, what were your two numbers?
5 and 5.
5 and 7.
5 and 10?
7.
5 and 7?
Same, 5 and 7.
1 and 5.
1 and 5. Who did you like best? First guy, the second guy?
Second guy, but I feel as if the word's just different, same characteristics.
They're the same words.
I know, but you're saying
You know
different
now,
order.
when I saw envious, that's when it kicks it. We just reverse the order. So, this 1 and 5, 5 and 7, 5 and 7. So sometimes you can see how you tell the story. I assume intelligent, industrious got better, Clinton got more than Jeff, or is it the other way around? Second
Yeah,
person
Clint gets
higher?
better than Jeff.
All right, they're the same stuff. Right? Envious, stubborn, critical, impulsive, industrious. Make sure I can cheat. Yeah. Envious, stubborn, critical. So we just reverse the order. We got, and you, good, smart people, good young lawyers, had a deviation, right? So think of your training and your background and your education, and now you've got a group of jurors, many of whom have not gone to college, many of whom don't want to go to college, and you're going to have 4 or 5 that are going to do graduate work. So if it works, if you guys who were skeptical, the lawyers are skeptical by nature, if we have a different feeling, they're going to have significantly different. All right, Clinton, you won with that. Jeff's my son, Clinton's my stepson. And they don't have many of those. Well, they got good work. That wasn't derogatory. How you are perceived by jurors is going to start when you walk up. Ladies and gentlemen of the jury, I'm Joe Souza. I represent Penny the plaintiff. And we're going to start talking a little bit about this. Part of the case is called voir dire. I would tell you one of the tricks I've used for 40 years, I read it in a book 42 years ago, was when I first came out of law school, I was told, and this is true, what you don't want to do is you do not want to pry, and we're not trying to, when asking all these questions about how many cases you've ever been involved in, do you smoke, do you drink, has anybody in your family ever been addicted to a drug? We're not trying to pry into your personal life. We're just trying to pick the best jury. Well, 41 years later, I say, that's exactly what I'm trying to do. Don't fake the jury. When I ask you how many times on your juror sheet you've been involved in a number of lawsuits, tell me a little bit about them. Well, I was involved in a car wreck, my son was involved in a slip and fall. Did they come out to your satisfaction? They did. Did they have to go to jury trial? Did you prevail? Did it meet your satisfaction? If the verdict was good or bad? You're trying to find those things. So I no longer say what they told me to say 40 years ago. I say, yeah, it's exactly what we're trying to do. We're trying to get the best jury we can to sit and listen to this case. Some of you went to UK, some of you went to U of L, some of you didn't, and there's still U of L and UK fans. If you had to sit here and judge me because I have the big blue on, and you think I'm derogatory to U of L, or I got red and black on, and you think I'm never respecting the big brother, there's going to be some innate bias, right? And that's what we're trying to, those little things that are peculiar to us, that make us be the best person to sit and judge. I like this. If you're getting the first juror panel of their time there, 2 weeks, Elgin? 2 weeks?
2 weeks.
Yeah. In Bullitt County, Shelby County, Oldham County, they serve like 3 to 6 months. The juror information is available to you months in advance of the trial. In Louisville, we get them about 10 minutes before the jury is seated. And it is a fist fight with trying to figure out what, and I'm going to give you some stuff here you can utilize. So they may be nervous, they may be a little intimidated, it may be the first time they've ever truly spoken to a lawyer, many of them. They've certainly heard enough lawyers on TV, so maybe they embrace that, but actually sitting down in a room, speaking to them. So embrace it, all right? And here's embrace the moment. Take advantage of what they're feeling. Tell them that no matter how long you've been a lawyer, and no matter how many trials you've been involved, I'm still there. And I am. The first one, I went to the bathroom about 5 times before I could say a word. I was sick. I was so nervous, scared. So it's easy to say that for you guys. Ladies and gentlemen, as you can tell, hopefully you can tell, I haven't been doing this for a very long time, and I'm a little nervous. Maybe you are a little bit too. Okay? So if I am, hold that against me, not against Danny the defendant or Penny the plaintiff. All right? If it's 10 years from now and you've tried 15 or 20 cases, embrace the moment. Ladies and gentlemen, no matter how many times I'll stand in front of a jury, and I've done this quite a few in the last 20 years, I'm still a little nervous. So it's the same story, you just change the facts to fit your particular circumstance. I think it gives you believability and credibility. They don't like us. Why would they like us? Scandal, you got lawyers cutting people up and hiding people in trunks and hiding evidence. And we're not depicted in the best of light for your generation compared to his and mine. His generation and my generation, the difference. Have you ever seen Kill a Mockingbird? Do you remember who the slow guy was, the guy that saves her in the boot? Do you remember who he was?
Yeah.
It's Robert Duvall.
Robert Duvall.
That's how long Robert Duvall was. I saw it. I couldn't believe it when I went back and looked at it. So here's the way lawyers were depicted when we were growing up, and this is not important for you guys in terms of how you feel about lawyers, but the jury panel, the guys that are 50, 55, 60, 65, the boomers, that's what we grew up thinking about lawyers. Right? Honest, trustworthy, smart, diligent, great actors depicting lawyers of high character. Now, I'm just giving a random sample. It's like a clown suit over there. The Good Wife, Better Call Saul, Scandal. You got people yelling and screaming on TV, judges slamming the gavel down, making them look like fools of themselves. Now you have great actors depicting lawyers with low character. So, depending on whether you're talking about Generation X, millennials, boomers, and as I remember the statistic, will come up here in a minute, about 9% of the jurors are 18 to 25. And about 9 to 13% of the jurors are over 65. The vast majority, well over 50%, almost 76% of the jurors are going to be in that 25 to 64 range. So you're going to have a mixture in there, Generation X, Y, millennials, or boomers. So remember, that's what they think of. They grew up thinking of Matlock and Atticus Finch, and now they've got Better Call Saul. Researching local demographics, I'm not going to spend a lot of time on that. 9% from 18 to 24, 30 from 25 to 44, 23, those are just numbers, and they will be in that material that you can call them. Jefferson County has about 20% Afro-Americans. The Commission on Racial Fairness, 11 jury pools, only one had 20% of jury pools who's black. So if you are representing a black individual, an Afro-American man or woman, you need to be cognizant of those. That's going to be the vast majority of your jury pool right in there. Okay. Licensed drivers, we don't need to spend a lot. Jury selection process in Jefferson County, it's moments before the jury's seated, you get a stack of things. And unfortunately, it's one of the, I don't know if it's disgraceful, but it doesn't help lawyers. Now you've got juror number 674439. And juror, your number, 974, you can't be personal do you mind if I call you Ms. Johnson, or do you mind if I call you Mr. Kroll, or Mr., you can't say that, because I can't remember those numbers. I can remember that's Mr. Johnson and Mrs. McDevitt, that's Larry Fitzgerald, I can remember that. But, in Bullitt, Shelby circuit, those circuits, you can get those stack of jury information weeks, if not months ahead of time. You can do a whole lot more research on who you want, who you don't want. We're going to talk about social media for the example. No names, only numbers, difficult to establish rapport. The case is in there, I'm not going to go over it, it's in that written materials. It's the case where the actual selection of the jury panel was probably in, you're supposed to pick, the panel's supposed to be, if you're going to have 2 alternates, 14, plus the number of peremptory challenges. That's what's supposed to be the panel. So you don't have to interrogate 50 or 60 people. But that case said that wasn't sufficient prejudicial error to reverse. Most of the judges, I think, are going back to the system. I'm not going to spend a lot of time on that. It'll be in your materials. New tools. You can go on, oh, I just didn't do that. Okay, anybody know how to get to the slideshow? Turn the mouse.
Just hit the from beginning icon there.
Which one?
Up at the top left.
Top left with your finger. I don't see the mouse.
Oh, there it is. Yeah, you got it. Yeah, you got it.
Oh, I see. Never mind, that won't work, will it?
Okay.
All right.
Thank you. I couldn't see the mouse. I haven't used it. Instead of putting a sheet, you've done this, I'm sure. You get a sheet from the court. All right. That mouse just seems to. You get a think there's not very much room in there to put your notes down. So I would advise you, in the limited trials you're going to get, because they're just not going to let you get the trial very often anymore, it's too expensive, is you got to have an assistant, maybe 2, maybe a second chair and a paralegal. You want to have more than 2 eyes observing those jurors when Elgin's asking questions or when Kristen's asking questions. Okay. It's hard to write down, didn't smile, it seems disinterested, dozing off, whatever you want to put in there, you need some assistance. So what these 2 jury apps do is they give you more availability to do that. It's pure technology, and I've used it, but it's a tool you may want to consider. Scary stats. Americans don't read the paper anymore. I don't need to tell you that. Our paper gets thinner and thinner every day. 95% of the information is what they see on TV. People, attention span 7 to 17 minutes. Remember, 15% of what they hear, 85% for what they see and hear is far more valid. So if you're in voir dire and you're saying something, if you have a demonstrative exhibit to show the scene of the accident or something, or something that, ice and snow, people said you assume the risk. It was a known and obvious hazard, but there's plenty of verdicts that say comparative negligence has to be factored in, and no matter how much snow, how much ice, is whether or not the landowner, premises owner acted reasonably to remove. Juries are skeptical of the court. They will be skeptical of you, no matter which side you jump on. 80% of them think there's too many lawsuits. 68% think we encourage filing frivolous lawsuits, and I will tell you, in 40-some years, I've seen one frivolous lawsuit get to the jury, and it was about a groping incident For a salesman, they got $600,000 or $700,000 reversed on people. I've seen one. So, but it doesn't matter. They think 68%. So that hurts. It hurts Michelle, Chris, and Kristen. It's helpful. You know, those juries do not like plaintiffs. Your job, this is the one I like the most, your job is not to act like a trial lawyer. What they see on TV, and the best advice I can give you, if you take anything from this today, is no matter who's in your law firm, and you come from a big, wonderful law firm, and I don't know your law firm as well. How many people?
There's just like 4 of us, 5 of us practicing.
Okay. They may or may not, you may or may not fit this, but don't try to be them. And don't try to be Kent Westbury or anybody else. You got to, if there's one thing I would tell you to do, try to remember who you were before you went to law school. It took me about 15 years. I'd walk in and say, ladies and gentlemen of the jury, I'm Joe Souza, and I'm a lawyer here to represent you, and I'd use a deeper voice, and I didn't feel comfortable. So if there's one thing I would ask you and urge you to do is whoever that person is in there that you like or don't like, don't try to be somebody else. Jurors adopt the trial strategy early, and once they're very resistant to change. So even though she represents Walmart, and even though there was snow and ice on there, if there was a lot of snow and ice, anybody should have known that. If they like that story, they're going to forget the fact that they had a procedure manual that said you're supposed to salt and or remove ice from the general walkway, and your lady fell on a walkway. So it's the juror's experience you must understand. So that's what jurors bring to the courtroom. You don't need to know if they're Democrat or Republicans or 50 or 60 or black or white or green or yellow. What you want to know is whether there are any experiences in their background that shed some light on your case. Have they experienced the same thing? Did their son or their daughter or their loved ones fall at a Kmart or a Walmart? Were they involved in a car accident? Did they ever feel cheated by a stockbroker? Whatever the issues are, they ever been convicted of a crime? Elgin's being convicted of one now.
I gotta be in court.
You gotta be in court.
Where I can make some.
All right, so that's important.
Yeah.
Despite all this rhetoric, it's important. Thank you, Elgin.
Okay, thank you.
Generation Y, millennials. Here's general thoughts from psychologists about them. Appreciate stability, individualism, diversity, closer to home longer, expected to change careers far more than their family did. No tolerance for intolerance attitude. They despise all types of discrimination. Nothing is more relevant about that than what happened at the University of Missouri. You have 8% of the University of Missouri population is Afro-American. They got the president removed, and apparently the president did a pretty bad job of being responsive or at least bit sensitive to the racial issues. Because he had 9 deans saying he needs to go. But they don't like it. That generation, 18 to 24, that's what they all are. You know, they were supportive. The whole student body was supportive. The football team was going to boycott. So that came to roost to me. That would not, you know, that's absolutely right. Liberal policies. If there's marijuana involved in your case, and you're the defendant, and you find out that they were smoking marijuana or they tested positive at the emergency room, if they're talking about that generation, they probably don't care. So, Generation X, which is 35. Okay, these are Generation X. Wealth is important to them. Mere participation, you know, the controversy about every kid on the soccer team gets a trophy. You know, there's good news, there's good about that, there's bad about that. You know, if the concept is to win and be competitive, not everybody should get a trophy. But my kid's got 20 trophies. I think 2 of them are championships. The rest of you just play. Trophy kid, that's what they're called. That generation called trophy.
Come on, you're speaking to us. Be nice to us.
Baby boomers, you know enough about them. First of all, they're only going to represent 10% of the jury pool today. As years go by, there'll be less and less of the jury pool. It's my generation. It's probably many of your bosses at Brown Todd. They know they're surrounded. They're going to be Vietnam, idealistic. But they definitely want the case to be proven to them. They're overachievers, me included. Worried about money, strong work ethic, most of them do. They come from that generation of their parents. My parents were second generation Italian and Portuguese. They're used to people working hard for a living. They better take some responsibility. My father was a 10-year Marine. He left the service because I got born. And he always told me when I got older, I said, Dad, you need to meet your mother and I here at 4 o'clock. I show up at 4 o'clock. He said, if you show up when I tell you to show up, you're 15 minutes late.
Try to teach yourself.
Be prompt. 5 or 10 minutes is prompt. Like traditional approach. When to use jury consultants? Often as you can, depending on the value of your case. They're very, very helpful. That's the hormone we talk about. Social media and other complex jury issues, and we're going to fold here very quickly. That is going to be, for your generation, critically important because it's so commonplace. Half the baby boomers don't even know how to Twitter. I don't Twitter, but I do other stuff. Change of venue requests, I've had one granted in 40 years. I don't think you need to spend a lot of time on it. You can have a pretrial order if you want to cover whether or not jurors can be involved with cell phones. They're not supposed to. But if you tell me you're trying a atherosclerotic disease and whether an MRI should have been suitable, and you're talking about Wegener's granulomatosis, one of my sad cases where a little girl choked to death in a hospital. Okay? I can guarantee you, as soon as they get home, they're going to look up Wegener's granulomatosis. They're going to do it. I don't care what they're told not to do. They're going to do it. You need to be cognizant of that. Social media, your generation, can't provide critical evidence in this whole trial. So if they've been involved in a car wreck and they're jurors and they said they weren't, or they hate lawyers, or they can't believe they poke them, people do it. Can't believe the stupid lawyer is going to think he's going to win this case or something like that. And also potential, are they friends of one in Shelby County, Bullitt County, it's far more likely to occur, not so much in Jefferson. But what are you allowed to do? That's the critical. ABA formal opinion allows lawyers to review jurors' internet presence in the courtroom while you're interrogating the jurors. You can look up, see if they're on Instagram, Facebook, social media. Anything that's public, you can get to. What you can't do, and what you will be admonished or disbarred for, is to have you or someone else in your staff, paralegal, non-lawyer, start asking to be friends with them on Facebook. Now, it's not going to happen in Jefferson County. You don't have enough time to select a jury. But the other counties, when they got 6 months or 3 months of juror stuff, you can find out some pretty interesting things, I would guess. You cannot do that so that, you just can't do it. I got a rule here somewhere. This is a case that's in your book. 2 jurors were internet friends, wasn't disclosed during the trial. So long as it's limited to what's publicly available, you're going to be safe. Okay? You can't get on, you can't send them a text message. You can't get on social media and put a post on their Facebook. But whatever I could, there's strangers, walk in and find out about them, you're going to be permissible to do. Outside of that, steer clear. That's a simple rule. This is for your. Is there a greater burden on trial counsel to use all appropriate methods and technology to conduct jury voir? Yes. I think the standard of care for your generation in terms of doing voir dire, you better have access with your assistants or your paralegals to what that juror says on Facebook, or what he has on Instagram, or what he has on his email account, or anything else that he might publicly blog about. If you don't, and you get an adverse verdict, somebody's going to be looking over your shoulder and saying you should have done that. spurious conduct, you gotta report it to the court immediately. A good, yeah, there's a good word. Read everything that's public, and don't make any, and you make nothing public. All right? Don't need to do that. Ethical considerations. You know, even if it's adverse to your interest, we have an ethical and moral obligation to tell the court. There's a case called Brown versus Todd that adverse to our position. We don't think it's applicable in this case, Judge, but and the reasons are as follows. We have an obligation to do that. It may not help you in your case, but it will go a long way to establishing your personal reputation with the other lawyer and with the court. And that's what you're trying to do. That's what you're trying to generate. You're building that foundation. So it's up to us to convince them we're honest with it. You don't expect them to give it to you. We talked about that. You expect to earn it. You're supposed to act properly with other counsel. It's nothing more upsetting to me to hear lawyers fuss at one another. I was in court about 2 weeks ago, and some prosecutor had gone behind the back of a defense lawyer and talked because the defense lawyer wanted a continuance. And he had a trial coming up in Kenton Circuit. The prosecutor went behind the lawyer's back, found out that the case was going to be tried like a week before the jury was supposed to be seated in his case, and made a fuss to the court, made a fuss to the judge about it. And the judge didn't climb all over the lawyer like I would have. But, you know, the difference between preparing for a trial in 5 days and 3 weeks is significant for a lawyer. And the fact that his trial might not go out that long and might truly have actually been a conflict was beside the point. I thought the prosecutor went way overboard. Professional courteous. Nothing will hurt your reputation more. I'm going to give you 2 quick examples. Truth never hurts anyone. It's a phrase I've used for a long, long, long time. Whether it's your case, good or bad, the truth never hurts anyone. I'll give you 2 examples and then I'm going to leave you. This is all in your way of contact with jurors. Two examples. I'm going to go in reverse order. About 15 years ago, a very detailed status letter on the status of malpractice case in Paducah, Kentucky was sent to my client. Dear John, this case is coming up for trial in 6 months. I want to let you know here's this current status. The opinions of our expert are as follows. The opinion of the other expert are contradictory to that. I think there's going to be significant problems. You know, the jury verdicts, only 15 to 20% of verdicts are won by plaintiffs at trial in malpractice. I estimate the value to be somewhere in some pretty detailed 3 or 4 page letter. It was inadvertently sent to the defense lawyer by my secretary. Not her fault. I should have made sure. Buck stops here. The defense lawyer calls me the day he gets it and says, Joe, I think I received something in the mail that I shouldn't have received. I said, well, what was it? He said, well, it's a letter dated such and such. I think it was to your client, but somehow it got sent to me. And I'll tell you his name because that's how much I admire. My name is Rick Straw. He's a defense lawyer in Western Kentucky, Paducah. He's won like 40 malpractice cases. Fine guy. He said, I'm going to tell you what I'm going to do. I'm not going to divulge this, and I'm going to throw it away. I said, thank you, Rick. About 4 months later, we had a mediation in the case, and we settled the case for about 4 times the value I put in the letter. So that lawyer is like up here for me. Good day. The dissenting opinion lawyer is a gifted trial lawyer here in Louisville. I'm not going to tell you the facts of the case because you can look them up, but he's a gifted trial lawyer, plaintiff's lawyer. We were defending it. Got hit for a pretty serious multi-million-dollar verdict. In post-trial briefs, we cited cases. In argument in front of the court, he says, well, Judge, Sousa versus Brown and Todd says such and such and such. And that's supportive of our position. That's why you should not, I mean, it was interest, it was about punitive damages and whether they should be reversed on that issue. Post-trial motion, not in the appellate court. And I said, God, it didn't sound right. And my partner, Jennifer Hatcher, had a smartphone with her, and she pulled up the case. The quote he gave was from the dissenting opinion in that case. There's no lawyer I've ever experienced in my whole life that would not advise the court, Judge, despite this being the dissenting opinion, I think the logic should prevail. Or here's the quote out of that case, Judge, and even though it's a dissenting opinion, I think it makes the most sense in how we do. I have no problem with that. But to tell the court, this is the quote from the case in an oral argument, and not advise me in the court, I called him out. I said, Judge, I don't know how to respond to this. I said, Ms. Katcher's just shown me the case, and the quote that was just given by counsel is a dissenting opinion. And I said, this is my 39th year of practice. I've never had a lawyer ever do that. It's disingenuous to court, it's disrespectful to the tribunal, and it's entirely unethical. Judge didn't do a thing. I would have sanctioned the lawyer, but he didn't. So here's the examples. You could be Rick Straub, or you can be the other guy. Be Rick Straub. Okay? Thanks for coming.
Thank you.
Single lie destroys your whole reputation. In passing, you work your whole life to build a reputation, you lose it in a minute. Okay? Okay. Remember, wisdom is the knowing the right path to take, integrity is taken. That's a pretty good quote. If you guys want that information, just email me or give me a call. I'll send it.
I'll probably take you up on that.
I hope you will.
Thank you.
Pretty good stuff.
Thanks again.
You're welcome. Knowing we're such a cozy group, I would have digested that down a little bit more.
Very good. I got
Thank
a lot
you.
out of it, so I appreciate it.
You're welcome. Call me if you need anything.
I appreciate it. Thank you.
Who? Where are they? Oh, Rebecca Sheila, sure. The former president of the bar. Yeah, I know that. Yeah, they're very, I don't know them all, but I know Rebecca.
It's a small group, a big group.
Well, that's really important. How long have you been out?
I graduated in 07, and then I worked for 4 years.
Who's your clerk?
I worked for Ted Lowe on the Appeals Court and Magistrate Judge Tim Baker in Minneapolis.
Oh.
And we moved here. And so that's when we
Okay. Thank you.
Thanks.
Enjoy it. Hey.
The basket right there on the counter. Yeah, right here.